has also expressed to me that he'd like the detail behind a number of high-profile claims. For example, Jo Hamilton claims that her original offer went from 20% of her original claim to 80%. Why is that? Christopher Heads was only 15% of what he claimed. Why? And obviously, as referenced above, Alan Bates's claim. There's a note already being drafted on this. Your private secretary understood. And so one can understand why that you would wish to know the detail of what you described here as high-profile cases, because you might be asked about them. Was that the reason that you were getting into the weeds here?
No, of course, that's we're public servants. We act of public concern, quite rightly, but it was more about how the schemes were operating. Were they operating effectively? Were they operating on a basis of common sense? Were they operating on a basis that the benefit of the doubt was given to the claimant? All the things we had committed to do, and I would expect a compensation scheme to operate on that basis. So it was really trying to not resolve that particular claim to get it out of the newspapers. It was a case of, let's improve these schemes across the board, and so these were just examples of things I was aware of. I took the same view on things that weren't necessarily as high profile as Sir Alan Bates or Jo Hamilton. It was on people that I say contacted me directly. I would try and get the same answers in those cases.
And so is this kind of thing that we read here typical of you essentially carrying forward the rather strong sentiments that we saw expressed in your backbencher MP for when you went into office as a minister?
Yes, that's exactly right.
Thank you. That can come down.
Attention please, attention please. This is the test of the fire and voice alarm system. There is no need to take any action.
Mr. Hollinrake, I think we can continue now. We're about to turn to a new topic, which is Post Office governance and the provision of information to you from or by the Post Office and decision making. If we can start by looking at your witness statement, please. It will come up on the screen, page 6. Paragraphs 19 and 20.
Before I do that, can I just add to what I was going to say earlier?
Absolutely.
That was probably caught off it by the fire alarm. I suppose what I felt through this, having been through what I saw in the Lloyd's compensation scheme, that the legal system, for whatever reason, I'm not sufficiently qualified to opine on it, but treats people when they are mistreated terribly, especially big companies and the individual. And yet, when it comes to the compensation, the people who are responsible for the compensation, I felt, treat those people, hide behind the law in terms of properly compensating those individuals. And I think there's something fundamentally wrong with that. And this isn't the only time we did it. You know, the fact in the Lloyd's scheme, we handed the compensation back to Lloyd's to provide the compensation. The fact in the HSS scheme, we handed the compensation scheme back to the post office to deliver the compensation. I think, A, that doesn't give anybody confidence that the compensation will be delivered properly, but also then it becomes very legalistic. And I think there's something very fundamental we need to learn from that. Some of that was covered under the National Audit Office report on this, but we should never do it like this again.
Can I ask you two questions arising from that answer? You said that when providing compensation for those that have been wronged, we tend to, quote, hide behind the law. That tends to suggest that you've taken the view that those that are providing compensation or determining compensation are not applying the law as they would see it.
I don't think that. I don't think it was, they're not applying. I think they're applying the law too strictly. In that this is how we compensate people according to the principles of how a court would deal with this. So and this is how we arrive at the calculation that we would through a very complex assessment of loss. But I think that's, to me, that is too much. We need to too legalistic, too adversarial, and it doesn't give the benefit of the doubt to the claimant, and it becomes very, very bureaucratic, and there are some basic principles of how you compensate people through the courts. I understand that, but I think applying purely legal principles to this, I'm sure there are very good reasons why that happens, but does mean that these compensation schemes, to me, can be flawed.
Can I explore that part of the answer a little further? Is your view or your complaint that the law is used, i.e. the common law and statute law, in determining the amount of compensation, or is it that lawyers are involved in the administration of the scheme?
Yeah, I think it's a bit of both, but you know, if two lawyers are arguing, that can take some time. And again, I'm outnumbered in this room, so I'm not trying to be critical of the legal processes. But you know, to me, there should be, as the National Audit Office said, and one of the things we tried to do and probably failed to do. I made mistakes here. I'm not saying, you know, I was the only person who did anything positive in this space. Not at all. Many good things were done by many people, both ministerial and through the civil service through this process. But I think there is that you need somebody independent of the legal processes sat in the middle somewhere to be able to sense check some of these things that are happening, rather than applying the strict rules of engagement, the rules of compensation in these situations, because that will just take too long and not properly reflect the situation that people have faced or the losses that they have incurred.
The second follow-up was that you said in your first answer after the fire alarm that we handed back or handed to Lloyd's and then the Post Office responsibility for administering the scheme, or in our case, some of the scheme. What's your, can you develop, please, your complaint or view there?
Well, I mean, the culture of the Post Office has been discussed at length. So people are bound to feel there is some of that remaining within, in terms of the claimants, and I think that probably some of that was remaining. You know, I think, but there's going to be little confidence from a claimant when they feel they're being compensated by the organisation that's been responsible for the huge suffering that they've experienced, that they're going to get properly compensated, and that suffering has been properly recognised. So I just don't think that's the right way to do it.
Was it an active question within your 18 months as a minister, under consideration of whether the Post Office should be given or should retain responsibility for administration of any of the schemes?
So yes, certainly. And again, you know, I know, so when you've stated this in the past, you know, in terms of, you know, we are where we find ourselves. So revisiting the HSS scheme, which had largely, by that point in time, made offers to the vast majority of people who had put claims in, starting out all again. Although we did, as you referred to in some of my earlier comments on this, is that we should put in place an appeal mechanism so people who feel they've been shortchanged could contest the compensation they've been provided with, and latterly, we also pushed for a fixed sum awards for those people, so compensation could be topped up to at least a minimum level. So yes, it's very much the case that I felt that shouldn't have been given to the Post Office originally, but it was. On later schemes, the GLO scheme was given was as in agreement with the claimants' lawyers, was done by DBT, operated by DBT, which I think was much better. I'm not saying even then you shouldn't do something slightly different than that in the future. But one thing that I was surprised about early on in my tenure as Minister, I think this decision might have already been made, but the overturned conviction scheme was then given back to the Post Office to handle, which again, to me, was a step backwards from understanding the GLO scheme should be handled by DBT, so independent of the Post Office. Then the first overturned conviction scheme was handled back by the Post Office, and that to me is the wrong thing to do.
Was it ever passed on to you that Mr. Reid, as CEO, and his board corporately did not wish for the Post Office to administer either the HSS or the GLO scheme?
I think the Post Office, including Nick Reid, would have been very happy if they weren't dealing with the compensation. That was certainly the conversations I had with Nick in the past.
And so why was it, if there was a meeting of minds between you and him, that didn't happen? Because
the decision had already been taken. The HSS had already been largely, like I said, most claims had been either resolved or offers had been made. The GLO we decided to do externally, which I think everybody was happy with. And the overturned conviction schemes, the original one, although it came across my desk, I remember making some comments on a brief that I'd had that I don't understand why this is going back to the Post Office, but I think a decision had already been taken by the Secretary of State at that point to do it that way.
The Secretary of State at that time being?
I think the original decision had probably been made by Kwasi Kwarteng. I can't be sure of that, but certainly it was a comment I made on the brief I received, that I didn't understand why this was going back to the Post Office.
Thank you. Can we then turn to the topic I was
Sorry,
going to? No.
Before we do, Mr. Beard, yes. I understand your concern about each side arming themselves with lawyers and arguing it out. I don't think I am a lawyer anymore, I can say that. I used to be one, but I'm not anymore. Anyway, but it was both the Post Office's choice and the department's choice to arm themselves with lawyers. They didn't have to have a room full of lawyers to argue this out. That was, if I can use the word, your choice. Yeah. You were collectively, you understand.
Yeah, that's right.
So why?
Well, as I say, I don't think we should do that in the future. I think we should have some independence set in the middle of it, and something that I certainly...
I appreciate about the future, but, and I'm absolutely not saying this in a critical sense, it's an inquiring sense. You obviously had considerable scepticism about how quickly lawyers could sort this out. So you become the relevant minister in 2022. Admittedly, HSS is well down the road, but the overturned conviction scheme wasn't well down the road, and the GLO scheme had hardly begun, right? So why not then say, right, we'll have a completely different attitude in the Post Office and the department. We won't arm our defence with lawyers. We'll have reasonable whoever who'll just look at these claims and make fair assessments.
Yeah. And if I had my time again, that's exactly what I've done. One of the mistakes I made. Yeah, it was very early on in my time as Minister that the GLO scheme came down the track. It was only after 2 or 3 months after, I think, and met with various different people, including people like Kevin Jones, Lord Arbuthnot and others, who were all seemed to be quite happy where the scheme was established. Now, looking back now, I don't think I should have been happy with that. I think there were scheme reviewers. Sir Ross Cranston was brought in as a scheme reviewer for the GLO. I think what I should have insisted on at that point in time was for someone like Sir Ross to play a greater role right at the start, rather than being the backstop for disputes. And I probably hoped, which is probably a vain hope, that process could happen more quickly. But it's too far down the line. So I hold my hands up. You know, I'm going to say sorry to people whose claims have not been settled quickly enough through that process. It's something I got wrong. I'm sorry that's the case.
Well, I wasn't actually, as I hope I made clear, necessarily saying you were wrong, but I was exploring the reasons why, in the end, this scheme, all schemes, have become, these are my words, and they may not turn out to be my final words, but apparently a battle between lawyers in certain cases.
That is definitely the case, and something we should not let happen again.
All right.
Can we then turn to the topic 2? It was paragraphs 19 and 20 of this witness statement, and this is after you become the Minister. You say, I continue to be briefed on issues throughout my time as a Minister. I have regular meetings with the lead departmental officials, David Bickerton, Director General, Carl Creswell, Director, Rob Brightwell, Deputy Director. And in those meetings, I'd often make requests for more information on particular topics and raise and discuss ideas for change. And then in 20, you say, it was also important to me that I should receive unfiltered information from stakeholders. And right from the start, I asked my private office to arrange calls with Nick Reed, Alan Bates, and Lord Arbuthnot. And so you're there describing getting information through the usual channels, i.e. through departmental officials, but also going directly to both the Post Office and to relevant stakeholders, yes?
Yep, that's right.
In your witness statement, it's paragraph 55, which is on page 14. Just by way of background, in 54, you say the government and Post Office have approached compensation with the best of intentions. There'd obviously been a number of problems, especially in relation to the pace at which sub-postmasters have received compensation or not. And then you set out some reasons, and you say there were, as I understand it, a number of reasons for this during my time as Minister. And then the first of those is slow and flawed disclosure at the Post Office, by the Post Office. Can you help us? What information were you provided with as to the Post Office providing slow and flawed disclosure in connection with the compensation schemes?
It wasn't information I was given by officials. It was just usually the case when I've spoken to victims, when or the representative of victims, or evidence we'd hear at the Select Committee inquiry, or things I would read in the various media reports. So that's tended to be where it would be revealed that was taking longer than it should.
And so this is disclosure by the Post Office in and for the purpose of a compensation and redress scheme?
Yes, absolutely. I'd speak to, obviously, the claimants' lawyers, and they would say to me, that's certainly part of the problem. I think that was a problem particularly early on, when the Post Office, to be fair, was getting up to speed with a lot of these cases. As we introduced things like the fixed sum awards, which are one of the things that have made a big difference in terms of making sure the flow of compensation increased. And there has been, I think, around a 4-fold increase in the amount of compensation paid over the last 12 months. I think now it stands at £438 million. It was just over £100 million this time last year. So many things have worked that we tried to do. But so one of the areas that helped in was the Post Office. By using that approach, it meant the Post Office had fewer cases to have to disclose evidence to, because the fixed sum awards don't require disclosure of evidence. So there is a twofold benefit from using that approach as one way to get compensation to people.
Other than the introduction of fixed sum awards, did you do anything in response to the information that you were given that the Post Office was providing slow and flawed disclosure? Well,
certainly it was a topic of conversation we had when I had regular meetings with Nick Reed and others, that we urged them to increase the pace of compensation. We were always reassured that was going to be the case. Again, on an individual case level, if things were brought to me, I would attempt to have those cases, understand why those cases were taking so long, and urge the relevant participants to accelerate the whatever information gathering was needed and provision was needed. We also set an SLA service level agreement kind of expectation on things like the GLO, that offers were made to individuals within 40 days of claims being submitted, but of course that's down the track from when claims could be submitted, because they would require the disclosure of evidence to make the claim. So there were some attempts to accelerate things, but we also brought in scheme reviewers, again, Sir Ross Cranston being on the GLO scheme, Sir Anthony Higginbottom on the overturned conviction schemes, which we were very keen to make sure that they could play some part in trying to make sure those schemes were fit for purpose. And indeed, the establishment of the Horizon Compensation Advisory Board with Lord Arbuthnot and Kevin Jones, I was very keen to make sure there was cross-party representation on that, but also there were people who had been fierce critics of the government on that board, including Professor Richard Moorhead, to make sure that they could have some oversight of how those schemes are operating and establish where things are going wrong, and be able to advise us on what we need to do to try and help.
You also cite, as a second reason, this is something you've mentioned earlier this morning, the fact that large claims were being held up by demands for detailed information on trivial issues, such as mileage travelled. Who was providing you with that information?
It would tend to be the claimants. I think this is something that Jo Hamilton, for example, has often mentioned to me, and when I've met her, there was information required that seemed pretty trivial and not material to what compensation might be offered, that would seem to have to form part of the claim before it was submitted.
And in relation to that, did you communicate any concerns about delays in large claims being essentially stalled by demands for trivial details to anyone at the Post Office?
So yes, certainly. That's a conversation we had in our regular meetings with the Compensation Advisory Board, how we do this a different way. It was very much the case that that I felt that there should be some sense checking rather than simply this getting sense checking in terms of what might be an appropriate level of compensation for those kind of things, and there would be and that there should be a way to give an assessment of somebody's loss without having to go into a detailed assessment of that loss. There should be, and this is something that was piloted, that there should be a general, there should be less of an expectation, less requirement for there to be a submission of individual loss at a financial level or in terms of people's health or mental health, that we should be able to work that on a basis of some kind of tariff. That was certainly a scheme that was piloted within the department that I understood helped to some degree.
You also cite, thirdly, the requirement that each claim had to be supported by medical evidence of trauma and physical impacts and forensic accountancy evidence for financial loss when these experts had limited capacity. And who was providing you with that information?
Again, that was a conversation I had with the civil servants, Creswell, Rob Brightwell, who were clear that there were some issues around there was a queue for getting the forensic accountancy or the assessment of somebody's impacts on their health, on their mental health, and those kind of things can take time, even when the people are working on those cases, but there's a queue of cases to be heard by those people who are experts in that field. If we could move, and I think we did this on a pilot basis, which I understood was successful, this was probably towards the end of my tenure as Minister, to have, say, a general kind of a lower requirement for assessment of individual need and more of a kind of general figure that could be put on that kind of loss that could provide a basis of compensation rather than a more detailed assessment.
You've mentioned a couple of times in your answers that you asked for the issue that was being raised in front of you to be sense-checked, or words to that effect. What did you mean by that? I sometimes find that when people use that phrase, it can carry a number of meanings, some of which obscure what's in fact happening.
Well, I mean, I think I used that initially in terms of Sir Alan Bass's case. You know, if you just look at the case, somebody's been campaigning for on behalf of, you know, thousands of people for 20 years, and then you make an offer of compensation at the level it was initially made. You just think somebody's been working for 18, 20 years on a case. You know, the amount of time it would require for somebody to work on that full time, and I'm sure he's working more than full time in his campaign. You can probably add it up pretty quickly that claim should be significantly higher than the claim was initially issued. And similarly with things like Joe Hamilton.
Just stopping there, you mean sense check in apply some common sense?
Yeah, that's exactly what I mean.
Okay. You were moving on to Joe Hamilton.
Yeah, well, similarly, you know, asking Joe to evidence her mileage between her home and her workplace, where she had to clean to keep to make sure she could pay for the things she needs to pay for and subsist, was just to me ludicrous.
There were proposals, thank you, that can come down, for upfront offers in a fixed sum. Where did that idea originate from?
It originated from me. I floated the idea at a departmental meeting with the Secretary of State and the Permanent Secretary and Dave Bickerton and others were at that meeting, and it was a frustration from myself and the Secretary of State, indeed, who was always very supportive of all my efforts to accelerate compensation, that things weren't moving quickly enough. And to be honest, again, I wish I'd recommended it earlier, because it was very well received by all the people at that meeting, that we should look at a different way of doing this. But the original idea came from an idea, you know, a principle, an approach we took at the Lloyd's HBOS compensation scheme, where we suffered exactly the same problems, even when the scheme was redone with Sir David Foskett as running the Foskett panel. Still, the compensation claims took a long time to assess those losses and to agree what the compensation level should be. So what we alighted upon was using this fixed sum award approach, which was very successful, and allows people to walk away from the process much more quickly and get compensation much more quickly and move on with their lives. Because as we know, and it's terrible to hear about Mrs. Riddell, and my thoughts are with her and her husband and others, how people have passed away without ever seeing compensation. It's simply wrong. And it's a way we can accelerate the compensation to make sure those people at least can move on with their lives to some extent after what's the terrible things that have happened to them.
Can we look, please, at Bayes 40808? This is a letter. I think we've only got this as an undated or finally dated draft, but it's dated August 2023. You'll see that it's from the Secretary of State, who was then Kemi Badenoch, if we just go to the top. Thank you. To the Chancellor, then Jeremy Hunt. Accelerating Post Office Compensation is the title, and Ms Badenoch's letter reads, Kevin, Hollinrake and I are both determined that postmasters affected by the Post Office Horizon scandal should get proper compensation. They should get it as rapidly as possible. 3 compensation arrangements are at different stages of maturity, and then you summarise, including some, she summarises, including some figures, the HSS, the overturned conviction scheme and the GLO scheme. Ms Badenoch continues, the scandal ruined many postmasters' lives. The longer compensation goes unpaid, the more criticism we shall face, including from the Williams inquiry. If we were to fail to compensate all the GLO members in time, we would face severe criticism from all sides. Kevin and I have therefore been looking at ways in which we could rapidly speed up the processes. We already make interim payments of £163,000 to almost all postmasters whose convictions are overturned, and we undertake only limited scrutiny of GLO claims for certain heads of loss under £10,000 and HSS ones under £8,000. We are looking to extend these measures substantially in relation to the GLO, which has started to receive claims. And then over the page. Some of the options we're considering would actually save more on the cost of lawyers or other advisors than they would cost in extra compensation. Others do have additional costs, but in my view, these would be well worthwhile in the light of the non-financial benefits of accelerating the schemes. In particular, I'd like us to be able to offer a £100,000 fixed payment to every claimant who applies to the GLO scheme. I recognise that announcing this would create significant pressure to offer the same for HSS claimants, which we should consider separately, but I believe this is the right route forward for the GLO scheme. Such radical action would offer great advantages in terms of the speed of the process. The Departmental Accounting Officer has expressed some concerns about the value for money given the repercussive risk and raised the potential need for a direction for this idea. That's a reference to a ministerial direction, yes? I would welcome your views on the best approach, being mindful of value for money considerations, whether you agree we should pursue this. And the letter was copied to you. So this was a joint suggestion between you and Kemi Badenoch. Is that right?
That's right.
Do you agree with everything that she's written?
Yes.
Can we look, please, at Bayes 40705? We can see from this, if we go back down to the bottom, please. So it's over the page, the end of the letter. Mr. Hunt, the then Chancellor, replied, and go back to the top. We can see in his paragraph 1, in his reply to the Secretary of State, Ms. Badenoch, that her letter must have been dated the 9th of August. And then if we scroll past paragraphs 2, 3 and 4, he addresses the request, the ask, in relation to the specific proposal for fixed sum awards on the GLO scheme. While successful delivery is paramount, we must also have regard to our responsibility for the public finances and to ensuring that the treatment of claimants on each Horizon compensation scheme is fair to that of their peers. As you note, making fixed sum awards on the GLO would incur significant repercussive risk and costs, including to the HSS. Given the extent of this risk and its high likelihood of crystallisation, I'd encourage you to explore the full breadth of other options to advance the ultimate objective of timely and successful delivery of full and fair compensation. And then the letter continues about some other things. That's essentially a rejection of the proposal. Is that right?
Yes, that's right.
It
As they
doesn't
fix
say
some
so. It in as many terms. It says please explore other options.
Yes, which we were, clearly we were.
What was your reaction to the rejection of the proposal made by you and Miss Badenoch?
Well, disappointment, but I wasn't surprised because it was quite a. I think Secretary of State had described the proposal as radical, actually, in a previous letter, and it is quite a radical thing to do. And a permanent secretary would never sign this off on value for money grounds because that's what permanent secretaries are there to do, to protect public money. Personally, I felt it was still the right thing to do, and we continue to press for it because I think Jeremy Hunt has always been massively supportive of everything I tried to do in terms of providing compensation to postmasters, as has the Secretary of State and others, and the Prime Minister, indeed, Rishi Sunak. But I don't think any of them had the experiences of previous compensation schemes that we had experienced, the ones I referred to earlier, particularly Lloyds and RBS. So I felt it was something we would, in the end, have to do.
Thank you. Can we move to Bayes 40722? And can we look, please, at the bottom of page 2 and on to the top of page 3? You can see an email from Carl Creswell to, amongst others, your email address. It's Minister Hollinrake. The rest of it has been redacted on data protection grounds. Is that essentially your private office?
Yes, that's right.
It wouldn't be to you personally?
No.
And this is essentially a record of the outfall from the decision that we've just looked at. We can see that it's in late September the 22nd. And if we go forwards to point 3, so if we just scroll down, please. Thank you. On 3, that's a reference to a point earlier in the email chain, which I'm not going to turn up. The CST, which I think means Chief Secretary to the Treasury, is that right?
That's right.
The Chief Secretary to the Treasury, that would have been, I think, John Glenn at that time, is that right?
I think it was, that's right.
That was before Laura Trott took over in November. The Chief Secretary to the Treasury has approved in principle a higher scrutiny threshold for group litigation order claimants. He has tasked his officials with agreeing a sensible level with us rather than picking a figure such as £100,000 or £50,000. Our current scrutiny policy is rather selective and just covers up to £10,000 shortfalls. So moving to a higher and less restrictive threshold as soon as possible would be useful and enable us to process more claims more quickly. Can you explain to us what the higher scrutiny threshold means?
It would mean when you did receive a claim, whatever that scrutiny threshold was, if it was below that threshold, then there would be a pretty light touch process in agreeing the claim. So if it's £10,000, what you expect to say it's less than £10,000, just pay it. And what the officials were keen to do, and I was keen to do, was raise that threshold. So if you got a claim up to, say, £100,000, that light touch process would be applied to that particular claim. So you wouldn't get into this lawyer-to-lawyer process of arguing about semantics, I would say, in many cases, about the level of the claim in certain areas. You just pay it.
And so by raising the level, you will bring more claims within the no or lesser scrutiny
That's right.
approach.
Yes. I think it's fair to say probably this is one of the alternatives to a fixed sum award. The difficulty with this in replacing a fixed sum award is that clearly you can't reveal this scrutiny threshold to the claimants, because everybody would just put a claim in if it was lower than that up to the £100,000 level. Let's say if that's where you set the threshold. So it's something you use internally rather than disclose externally.
The email continues. This leaves the question of our proposed upfront offer of £100,000, which the Chancellor is resisting on the basis of concerns about precedent for other compensation schemes, as well as potential repercussions. As we explained ahead of the recent Secretary of State meeting, we floated the idea of a £75,000 upfront payment with Treasury officials, but were again rebuffed as a matter of Treasury principle. Our understanding is that the Chief Secretary to the Treasury is sympathetic to our proposals from a political perspective, but feels unable to go further because of advice from Treasury officials about the impact on other compensation schemes, e.g. infected blood, and the strong views of the Chancellor. I'd be grateful for Minister's views on handling, please. So that's a direct request to you, is that right?
Yes.
In addition to reaching agreement at official level to an amended scrutiny threshold, even a level of £40,000 would enable us to process a significant number of GLO cases more rapidly. Minister Hollinrake, Secretary of State, could consider writing to Treasury ministers to represent the case to them and ask them again to reconsider. I prefer not to hold up progressing the scrutiny threshold because we're processing cases every week and it may take a while for that political conversation to reach a conclusion. I'm reading between the lines here. Can you help whether I'm correct in my reading between the lines? That there was a difference of view between the Chief Secretary of the Treasury and the Chancellor, and you were being asked as a minister to approach the Chief Secretary to the Treasury, i.e. at ministerial level, rather than going back to the Chancellor, who had expressed his view more than once.
I might be wrong, but I don't think the Chancellor and the CST did differ, actually. I think the CST was happy to look at, Chief Secretary of the Treasury was happy to look at higher level of scrutiny, but still had the same reservations about the fixed sum award, the upfront offer, as he calls it here, as the Chancellor did on value for money grounds. And I know this has been a topic of conversation, and you've queried it, I think, Sir Wayne, in terms of public money. There is a requirement within the work we do and within the civil service to protect public money and to look after public money. And it may seem callous in this regard, and I can understand why people might see it like that, but you've got responsibility to the individuals, their families, of course, to properly compensate them. You've also got to be fair them. You've also got to be fair to other postmasters, so everybody gets treated equally, but you've got to be fair to taxpayers as well. And so I do understand the grounds whereby ministers and officials would push back against the fixed sum award, because it does mean extra levels of compensation. It does mean more money paid out. So I don't think anybody pushed back on the higher scrutiny level, although they did ask us to decide upon or argue for what the right level. But the fixed sum award was more difficult to agree. It is quite radical. My experience was that civil servants, certainly Carl Creswell and Rob Brightwell, were very supportive of that, as was Dave Bickerton and the Secretary of State indeed. But when he gets to permanent secretary level, both in the Treasury and in DBT, Department of Business and Trade, at that point in time, somebody has to sign it off for value for money grounds. They would not do that. It would have to be ministerial direction, which I was very happy to sign if somebody asked me to do that, but I can understand why it's controversial.
Could you have been the appropriate person to have signed a ministerial direction? I
don't think without the support of the Secretary of State, realistically, or indeed the Chancellor, that would have been possible.
Do you think the Treasury regarded the Post Office scandal as the priority that you evidently did?
Yes, I do, although I probably had greater experience of it than some, perhaps, of the people working in the Treasury. So I think anybody who's had the direct experience by predecessor ministers or civil servants dealing in these cases, or many of the backbench members of Parliament, or many of the campaigners, obviously, here and further afield, knew how serious it was. I don't think until the TV series was aired that that was a view widely held everywhere in government and everywhere in the public consciousness.
What was your response to the Treasury's resistance to the proposals that were being made to it?
We'll keep making the case, as we did one-to-one conversations with various ministers in Treasury. You know, I perfectly understood the response because of the reasons I set out earlier about public money, but I still think it was the right thing to do, so we kept arguing for it. But in the meantime, I think as Carl says in this email, he says that we'll carry on with things we could do. In the meantime, things like the scrutiny threshold, which would help, while we're still continuing to make the case for fixed sum awards, as we'd got agreement to do in the overturned convictions. What this is really talking about is expanding fixed sum awards into the GLO and the HSS, as eventually we did.
Can we look, please, just before the break at poll 0044 8411?
Can I start before we go to that? Actually,
absolutely.
Just the reference there to the infected blood. One thing, and this is obviously not a matter for this inquiry, Win, but to me, the infected blood scandal should have fixed sum awards, and that's not a feature of that compensation schemes right now.
Can we go to?
I think I've got my hands full without that.
Understand that.
Thank you. This is a letter with which the inquiry is familiar. It's from some anonymous post office whistleblowers. I think you've seen this as a result of disclosure to you in the inquiry. Did you see this at the time?
Not at the time. This was about a week after the election was called, so that kind of correspondence would not be shared with me. It may not be shared with me in normal course of events, because I think this letter is unsigned, actually. So
yeah, it isn't signed. It's signed off by the poll whistleblowers. We can look at that at the foot of page 2. Yeah,
it's signed off on unnamed people, which I've got to say, in my experience as a member of Parliament, and you know, I think people who are not prepared to put their name to a letter, I think you're bound to think twice about completely trusting the contents of something that's not signed by an individual.
could you think the opposite, that the strength of views that expressed are to be accorded particular weight because the people who are writing the whistleblowing letter think that retribution will be taken against them if they are identified?
I think it's something you should read. I don't think you wouldn't read it, but I think it's, if somebody makes allegations that they're not prepared to stand up to the individual, I understand why somebody might not want to, particularly if they hold a position that might be affected by the claims they make. So I say, I'm not saying you shouldn't read it or ask questions on the basis of it, but I think to trust it completely on the basis it's not something you can then go and interrogate both sides. Clearly you can ask questions of the people who allegations are made against, but it's difficult. Obviously you can't go and ask questions of the people who have made the allegations.
Thank you. It's just one passage in paragraph 4 on page 1. The paragraph beginning, furthermore, it says key people are not being appropriately managed by, that's Nick Reed or Mr. Reed. You are no doubt aware that Ben Fote has been given significant time off work. He's hardly been seen this year. And for the last few months, he's been on permitted fully paid leave to allow him to prepare for his half day at the inquiry on Monday, the 3rd of June. Not only this, but he's also had a forensic lawyer assigned to him for over 12 months to assist with the questioning at the inquiry, costing the public, we're told, about £700,000. We're all wondering why on earth he has to practice so hard to tell the truth. And then it continues. Were you aware of this suggestion that one of the witnesses to the inquiry had had a lawyer supplied to them which had cost about £700,000.
I wasn't aware of that figure. I mean, it doesn't surprise me that they had legal advice. I had legal advice giving this, give evidence today to understand the process and what was expected of me. I was very surprised that anybody needed time off to be able to prepare for this inquiry. I've never had any time off to prepare for it.
But I think you're saying that because of the timing of this letter of 20th of May, it was within the PERDA period and therefore it wouldn't have got through to you.
Yes, I never saw this letter at the time. I only saw it, but it was given to me as part of the bundle.
And so it wasn't something, because on the one hand, you're campaigning quite hard for fair provision of full and fair compensation to sub-postmasters. And on the other, on the face of it, a relatively high sum of money is being expended for preparation to give a half day's evidence at the inquiry. But this didn't essentially arrive in your inbox.
Well, I don't know if it's true, but it seems an absolutely ludicrous amount of money if that's the case.
But it didn't get through to you.
No, I never saw this letter until I saw it.
And so you couldn't have caused it to be investigated or explored.
No.
Thank you. So might that be an appropriate moment for the morning break? Can we break until 11:05, please? Well, I think it's remarkable. Thank you, sir. Mr. Hollinrake, can we just continue on the issue of compensation a little longer and go back to paragraph 55 of your witness statement, which is on page 14. Thank you. You mention in B and C essentially evidential thresholds for the claiming and then the payment of compensation, yes?
That's right.
Are you aware that UKGI was involved in setting the minimum evidential thresholds?
No, I wasn't aware of that.
Were you under the impression that these were threshold? Well, who did you think set the minimum evidential thresholds?
Well, I guess I assume they were set by DBT, whoever established the terms of compensation that would form the basis of how the compensation processes would work. So I expected it would be the department in consultation with legal representatives.
Would you agree that medical records are necessary for those claims which allege some personal injury, whether physical or psychiatric, so that the severity of the injury can be accurately assessed?
I think that was definitely the principles of the scheme. I think what we tried to do later on is reduce the need for evidence around that. So you might say, well, somebody in these circumstances, we expect the compensation for somebody in that circumstance, whatever happens to them, to be at this level, and rather than the need for specific assessment of that, the impact on that individual. That's where we're trying to get to reduce the need for this evidential requirement. But to form a basis of somebody's claim, I think that I understand why that was part of the original scheme. Because every situation is different, therefore it's difficult to assess everybody's loss or impact on somebody on the basis of a tariff. But what we looked at doing later on, as I said earlier in my evidence, is maybe there's a way to do that without the need specifically for that to be evidenced. If a claimant's lawyer could say, well, this is the impact we believe based upon other experience we've had with other claimants, this should be the level of compensation for the impact they've had on their lives, and then hopefully that could be then agreed without needing for detailed assessment, which should accelerate the process of compensation.
And presumably you would be aware that in some cases obtaining medical evidence can benefit claimants by achieving a higher award, or, for example, where the expert recommends that treatment is necessary, then that treatment, the cost of that treatment can be part of the claim. Yeah,
and nobody would ever want to stand in the way of what any assessment that will lead to fair compensation of an individual's claim. It wasn't saying there would be a cap, it was simply saying, is there a way to expedite this on the basis you could have a sum that might reflect the impact on that individual that could be agreed between would be the claimant side, claimant's representatives and the representatives on the other side of the scheme, be it DBT or Post Office.
As to D, the involvement of lawyers on all sides, is it your view that postmasters should have the assistance of a lawyer for complex claims?
Oh, yes.
Are you aware that the department has rejected a suggestion that early legal advice, i.e. pre-offer for postmasters, should be funded by Post Office?
I think that the different schemes operate in different ways. The HSS operated on a different way. I think the legal advice came down the line rather than up front. So, which, you know, I think the idea behind the HSS scheme, as I understand it, was to try and take away some of that lawyer-to-lawyer friction and to try and make these claims, try and expedite the claims to make them be able to settle more quickly. I understand why that was done like that, but that may well have meant that people didn't get the right advice early on, which is one of the reasons we wanted to push for fixed sum awards on the HSS scheme, because there was a concern that things like consequential loss weren't properly assessed in the original scheme.
Are you aware that in most cases, the majority of cases in the HSS, they do not involve lawyers or forensic accountants' evidence?
I think I understood that to be the case, yes. It was supposed to be assessed in a non-adversarial process. So the panel of KCs and other experts were there to try and take an inquisitorial approach to assessment of the compensation and pay it that way. It was, as I say, an attempt to take away some of that lawyer-to-lawyer friction. But there may be concerns then raised that did people get the right advice right at the start?
And then finally on this, are you aware that for cases outside the parameters of the funding agreement between DBT and Post Office, the Post Office is required to wait for settlement offers to be ratified by the department, who then have, on occasions, to liaise with the Treasury?
I wasn't aware specifically of that process, no.
Can we turn, please, to the issue of the relationship, that can come down, thank you very much, the relationship of postmaster, non-executive directors to the board and with government. In a witness statement provided to the inquiry, there's no need to display it. The reference is WITN 11170-100 at pages 109 to 110. Saf Ismail, one of the postmaster Neds, said that he, quote, had conversations with individuals at DBT, namely Carl Creswell, and the minister, to raise concerns that the business of the Post Office was in a very precarious position, but that he felt ignored. Firstly, do you remember Mr. Elliott coming to you?
I remember we had a meeting, an online meeting with Saf Ismail and Elliot Jacobs, I think, to discuss where the Post Office was and their role within it in terms of being non-executive roles and the potential change of chair. And of course, I can't think specifically. I can't remember specifically them saying that that things. I don't remember them saying everything is fine. Nor can I ever remember them saying that things were disastrous and unfixable. And certainly, my feeling was in that conversation that we had with them online in that meeting was that they were both very keen on the new chair we were recommending to take over at the Post Office, Nigel Relton.
Can we look, please, at Bayes 301020? You'll see this is an email from and to your private office email address, yes?
Yes.
And this is, as we've seen in the past, a means sometimes employed of recording a meeting, an email to yourself, essentially.
That's right.
In this case, it was from Jamie Lucas again to himself. Essentially a minute of the meeting. Is this the meeting you were referring to?
That's right.
It's the 28th of March this year. and you'll see that it records in a sort of semi-verbatim fashion what was said, with you being referred to as Kevin, Mr. Jacobs as Elliot, and Mr. Ismail as Saf. You'll see there's some quite general information passed, and essentially sort of pleasantries right at the beginning, where I think you were presumably warming each other up at the beginning of the meeting there. And then if we look at the second paragraph, you say we're on the same page on central costs. And Mr. Elliott says the minimum wage is becoming a problem. Bottom of the page, you say agree with what you said, the top and the bottom of it. This is essentially about not horizon issues at the moment here, speaking about essentially the future of the post office. And then over the page, they say that it's a lack of the roadmap that's a problem. We live in, I think that's supposed to be a never land between sustainable business and social purpose. You ask who your standout is. Mr. Jacobs replies, Nigel Relton. Mr. Elliott, Mr. Ismail agrees. And then it continues. What was the purpose of your engagement with the Postmaster Neds in this way?
I guess to find out what was going on at the sharp end and what they really felt about the business. And I was keen to have their confidence that we were truly interested in making sure that the Post Office had a viable future, not just as a network, but also at an individual postmaster level. So I always like to talk to the people who are at the sharp end, and I think both Saf and Elliot are both operators as well as non-execs, so they are postmasters as well as non-execs. That's the reason they're on the board. So very key to hear from their perspective, but also for them to feel that they were being heard.
Was this part of a regular series of meetings with them, or was this essentially a one-off?
I think it was a one-off, although I had spoken to them in separate situations when I attended a board meeting, and I think when we were at various conferences, National Federation, the Sub-Postmaster conferences as well. So it was never something I was afraid to do, talking to the people who were the operators of the network themselves.
In general, what was your relationship like with the two Postmaster Neds?
I think good. I say it wasn't a day-to-day working relationship, but I hope they felt that I was willing to listen to what they had to say, and the responses I gave them were what I truly felt. And as it says in this exchange, I did agree with a lot of the things they were talking about, particularly the need to reduce central costs so that more of the revenue that flowed into the post office centre then flowed out to the postmasters who are actually doing the day-to-day business at the sharp end.
Do you understand how Mr. Ismail feels able to say that he felt ignored after his conversation with you?
I would surprise that's the case, but if that's how he feels, that's how he feels.
Did you take any action as a result of the things that they said to you in the course of the meeting?
Well, I think the principal thing we were talking about here, which is what we certainly agreed on, was the need to cut costs at the centre, which is something that I was very keen to do. That was something and other members of the Post Office Board I got frustrated. I think I said in my witness statement that didn't happen more quickly, but that was certainly a conversation I had with Nigel Railton when we first met about the potential for him to take over as chair. and I understand Nigel was always very keen to do the same. He felt the same, and I think he's spoken subsequently or recently about his plans to reduce the costs at the centre, which definitely need doing. So I don't think there's anything in here fundamentally, if we're talking about central costs or the shape and size of the network, which are both are matters for consideration and action, or anything that I didn't agree with or wasn't willing to act upon. So I'm surprised he felt ignored. I'd be very happy to have a conversation about why he felt that.
Thank you. That can come down. Turning then to the issue of cutting central costs, can you firstly explain in summary terms what you mean by cutting central costs?
Well, it's not. I had a business background, and when you hit trouble in a business, and as the network has, and lots of those troubles have come as a result of customer behaviour, as well as other matters in terms of how difficult it is as a postmaster to make a living. So we use high street shops less than we did before because people have different ways of shopping. I understand that, and so the post office and lots of the services we used to get from post offices, such as our driving licence or passport, many of us do online now, which has hit postmaster income significantly. So what you do when you're in a situation where your branches are less profitable, the first thing you should look to do, in my experience, is cut costs at the centre, because they are not the most important people in your network are the people who are serving the customers day to day, because they're generating the revenue. So what we'd expect to happen, therefore, is the size at the centre, particularly the executive and the management team. You look at how many people you have in that executive management team, and you look to cut it. And typically what I did on my own business, when we hit trouble in the past, you would have cut that by at least 40%, if not more. And that's some of the conversations we had with the chief exec and their team, and the finance director, the acting finance director, the acting CFO. How many people were at different salary levels within the organisation, and what was going to be the direction of travel in terms of reducing the costs of those people at the centre. There are other costs as well, and the plans to reduce costs of directly managed branches, for example, which are a significant cost, and to Post Office Limited, and that was something we discussed. But certainly focusing on the people, the management team at the centre and the executive team. I think 143 people and £100,000 or more, and you expect there to be a direction of travel in terms of reducing the numbers of people who earn that kind of money.
Can we turn, please, to page 8 and paragraph 30 of your witness statement? Under the heading Post Office Board and Culture, within paragraph 30, you say this: there are also signs that the Post Office remains too inward-looking and dysfunctional. And then examples of being too inward-looking and dysfunctional you then give. You say good examples are the failures to disclose information to the inquiry. 2, the slow pace of disclosure for compensation cases. 3, the reluctance to reduce central costs to allow a consequential increase of revenue to postmasters. 4, the Henry Staunton saga. 5, the failure to deal with long-standing issues with senior executives, such as Alistair Cameron. 6, the Remuneration Committee's decision and processes around the sign-off of bonuses for complying with the inquiry's disclosure requests. 7, the persistent and aggressive lobbying by the CEO to significantly increase his remuneration. It's quite the list.
Yeah.
Amongst those matters that you mention is a reluctance to reduce central costs to allow a consequential increase of revenue to postmasters' remuneration. The way that's written, I take 2 things from it. Can you tell me whether I'm correct to do so? Firstly, that you drew a link between the reduction of central costs and the increase of revenue to postmasters?
Well, inevitably there is.
Was that the purpose of the reduction in your mind of central costs?
Yes, of course.
And then the second thing is there was a reluctance to do so by the,
Yes.
by the post office.
Absolutely.
Who within the post office did you detect a reluctance in to reduce central costs?
Well, the chief executive. I mean, the chief executive carries the can for everything, and it's not easy to be a chief executive, and it's not easy to be a chief executive of an organisation that had hit so much trouble. So I sympathise about the difficulties of running this organisation, but that I don't sympathise with doing things that were clearly needed to be done. And had Nick Reid come back to me and said, "No, you're wrong, Minister Kevin, what you want to call me, we need to keep those people for this, that and the other reason," then I would have listened to the argument, of course, but I never heard a compelling reason why that should not be the case. There was, as I understood it, acceptance that this should be an area where we'd look to save costs. That could mean then more money flowed into the postmasters themselves. But then nothing happened about it, despite our urging at every juncture, into every meeting, and you could easily say, well, you should have done more, and I would hold my hands up and say, I should have done more to insist upon this, but that was never properly forthcoming. And that, to me, is a failure of leadership.
Can I look at those two things that I've taken from the sentence and that you've confirmed then? The first of them is the link between a reduction in central costs and increased remuneration for sub-postmasters, and that as an aim, by looking at poll 0044 7841. You'll see this is a letter from you to the then chairman, Mr. Staunton, of the 29th of June 2023. It's a 5.5 page letter, including its annex, and its heading sets out its purpose, namely to set out the strategic priorities for 2023 to 2024. Could you just explain why you write letters of this kind and what their purpose is?
Well, obviously, we are the shareholder for the organisation, and therefore it's sort of to us to set out the priorities that then the chair and the chief exec should then focus upon.
Page 2, please. You say, I would like you to focus on the following priorities and align the reward package to the shareholder priorities. So align the reward package to the shareholder priorities. What does that mean?
Well, I would guess that's a case of the any bonuses that would be due to senior executives should reflect the priorities that's set by the shareholder.
Okay. 1, effective financial management and performance, including management of legal costs to ensure medium-term viability. For the financial year 23 to 24, the Post Office should, and then as the 4th bullet point, maintain stringent cost control and maintain a clear focus on value for money and efficient delivery across the cost base, including, and then there are 5 sub-bullet points, the last of which is other measures aimed at reducing central costs wherever possible. So is this the record, essentially, of you telling the Post Office to reduce central costs?
Yeah, I mean, that's one of the records. Other records are contained within the meetings that were minuted between myself and Nick Reid.
But this is a particularly formal way of doing it,
yes,
by setting out the shareholders' strategic priorities. Is that right?
Yes.
This says that the direction to reduce central costs has as its aim the medium-term viability of the Post Office. Yes?
Yes.
In the heading at
That's
the
right,
top.
it says, yeah.
rather than with a view to increasing postmaster remuneration. And in the letter, it doesn't set out as a strategic objective the need to increase postmaster remuneration, or that the post office should work towards that. Was that a strategic priority?
Well, yes, it definitely was. It wasn't a case I was trying to do this to reduce the contribution by the taxpayer. It was a case of, from my focus, it was very much all the conversations I had with postmasters, be it through the conferences I attended or by other means, was very much an understanding that life was difficult as a postmaster. Many were working at or below minimum wage, and the post office itself would not be viable if its network would not be viable. So that's the most important part in terms of viability of the network, in my view.
And if we just look through, if we scan through the 4 strategic priorities, there's a mention at the foot of that page there in the last bullet point under number 2 of postmasters, but that's in the context of rolling out to them the strategic platform modernisation programme. So far as I can see, that's the only mention of postmasters in the strategic priorities. If we go over the page and look at priorities 3 and 4. Are you saying that it was to be taken as read that postmaster viability and as part of that remuneration increase was a strategic objective?
Well, I don't think anybody who had an interaction with me in terms of the management team or leadership team would have any doubt that it was my intention and a requirement of their work to make sure that we reduce costs, to make sure that the beneficiaries of that should be the postmasters. It may not specifically say this in here, and maybe it should have done, but that was certainly the case. That's what we were intending to do.
Can I look at, thank you, the next part of the equation then in that sentence that we read, which was that there was a reluctance within the post office to reduce central cost. By looking at Bayes 40805. And I think this is essentially a presentation or a series of slides for a presentation for a meeting that was held in December the 5th, 2023, which I think you attended. Yeah. And this is part of the post office presentation to you, or to the meeting at which you were present. And it's, I think, annotated up the slide pack if we look, for example, at page 3, presumably by somebody at the department, because this was disclosed to us by the department. Overall, can you just describe the purpose of the meeting? Can you remember?
Well, obviously, central cost is mentioned there, and one of the, I think, the next slide then talks about the number of people on high salaries. So I'm not saying the only purpose of the meeting was to look at central costs, but as far as I was concerned, that was one of the most important areas for discussion at the meeting.
Can we turn to page 7, please? Further scope for self-help is possible, but this either involves trade-offs in the near term or it delivers benefits outside the 3-year plan. And this is the post office speaking, essentially. We have cost savings targets for the financial year 23 to 24. I think that's a reference back to the letter that we just looked at. And we'll have further targets for 24 to 25. And then, however, cash constraints limit what we can deliver in the near term. If the department was to do something, and noting the substance has been flat for 5 years, we would have to do something. We would have more funds to support cost-saving activity. We know our costs can and should be reduced, and we have a track record of taking costs out across our business over the last 10 years. But to have any material lasting impact, we need access to funding. With limited capacity, tight cash and uncertain future funding, working up detailed cost saving plans is speculative and high risks. Plans developed today can only be implemented today. Is this, was this Post Office saying to you that cash constraints limited how far the Post Office could cut its central costs further than it was already doing without government support?
Yes, that's right. That's what they're saying.
Do you agree that government constraints, in fact, significantly limited how far Post Office was able to go in cutting central costs?
No, I don't. And I've had the conversation, I think it's been minuted elsewhere, that whenever we discuss this, there are things like directly managed branches, for example, redundancies at the centre. All these things cost money. In the short term, there's a short-term impact when you make these decisions. I completely understand that. My clear message to Nick Reed and others was you make the business case for that investment that we would need to get from Treasury to make those, to fund those changes, and I'll make the case for you to make those changes. So there should be nothing that would stop Nick Reed or others making the business case to me, and if it made sense, I would have taken that to Treasury to get the money if that made financial sense to do so.
So is this what you were being told on this occasion evidence of or an example of the reluctance to reduce central costs that you've described?
Well, it was one of the barriers that might put us in the way. The response I always get to that is, fine, okay, we'll come back with a business plan to do that. I never got that business plan back. So there was never a clear argument made to me to say, okay, you put X amount of money in here, we can deliver that, we can bring that money back to you in savings or in terms of how that may work over a period of time. And so that was never the case that was never the case that case was made. I've heard this a lot from a business perspective, how that you need people at the centre to do all the work at the outside, and even though the outside is getting smaller, and clearly in many ways the branch network is getting smaller because some of those branches are not physical branches anymore, they're drop and collects and other things, yet the centre remains the same size. And to me that's wrong, that's the wrong emphasis. The first thing you should do is look to reduce costs at the centre, but it's not uncommon that the management team at the centre don't want to do that because there are lots of people they work with on a daily basis. So it's a difficult thing to make redundancies. I've been through it. It is heartbreaking. You are letting people go you worked with for a long time, but that doesn't mean that's not the right decision to make. And but the difficulty here was it just did not move forward at the pace it should have done.
You tell us in your witness statement that the solution is good leadership. Nothing can replace that. It's paragraph 48.
Yes, I said that.
Would you accept that as the government minister for this 18-month period, you had a role in the leadership of the Post Office?
Yeah, of course. And you could easily make the argument, I failed, I should have pushed harder. I will hold my hands up to that effect. The thing is, you can't do it for them. The chief exec there for a reason paid a lot of money to do that job. The chair the same. And the other members of the management team, you can see how many people in this organisation. There are 43 people, I think, in the organisation paid more than £150,000 a year. So you'd expect those people to be competent at delivering on priorities set by the shareholder.
You say this of Mr. Staunton, if we turn it up, please. It's page 9 in your witness statement. at 34, which is at the bottom. Whilst I did not have regular contact with Henry Staunton, as Nick Reed was my principal point of contact at Post Office, my own view of Mr. Staunton was that he was incapable of chairing this organisation. I first started to doubt his judgment only a few days into my ministerial role, when he strongly advocated a very large percentage increase in the CEO's remuneration. I was very aware from my meetings with senior officials at UKGI, Tom Cooper and then Laura Grattan, that they did not rate him very highly and felt he was a chair from a previous generation. Given that you had doubts about Mr. Staunton as soon as you took office and heard from others about his inadequacies, but why did it take a considerable period of time after then to essentially move against him and ensure his removal?
I don't believe you should go around sacking people on a whim. You know, I always try to work with people in my business life and also in this life in trying to give people the opportunity to get the job right. Now, that was an early reflection in terms of the remuneration point. It wasn't handled directly by me. It was my Secretary of State, Grant Shapps, who handled the remuneration situation. So, but certainly a chair coming along and arguing for, I think I've never seen the letter, but I think it was a doubling of Nick Reed's salary. I think we all were pretty shocked by that within the department. So at that point in time, red flags appeared, and I think it wasn't the only time he made that case. But you know, I say it wasn't my principal point of contact as we went through this, and certainly it was only latterly we heard that Mr. Staunton's allegations, I think proven allegations of misogyny and racism and bullying, these kind of things that he was alleged to have done. You know, over time it became the case that I think it was quite clear his position was untenable, and that was a position that was held by UKGI and the civil servants responsible.
Why did the senior officials at UKGI not rate Mr. Staunton very highly, so far as you understood?
I just don't think they felt he chaired the board very well. I think if you look at the report that was done separately evidenced by Grant Thornton, talks about some of the processes, meeting discipline, lack of structured management information, all those things a chair is responsible for. So I guess that was a reflection of some of those failures at board level, and that's very much the responsibility of the chair.
In paragraph 36 of your witness statement, you say you're aware of Mr. Staunton's allegations in which he claimed that a senior departmental official had told him to go slow on compensation for sub-postmasters, and also about the reasons he was given for his departure. And you say, so far as I'm concerned, this was nonsense. Can you explain why you think that what Mr. Staunton has alleged was nonsense?
Well, I just don't imagine who he had a conversation with on that basis. And if you look at Mr. Staunton's evidence to the Select Committee, after he was let go, he actually says there's nothing wrong with the HSS schemes. I think that's, again, evidence within my witness statement, that he said that bit of it was going fine. Now, I think anybody who's been through this process as part of HSS would not say everything was fine with the HSS schemes. We know there were problems with that. In fact, he refers to that in one of his other emails about this claimant who received £16,000. That's one of the concerns he raised. So I just do not think that Mr. Staunton's evidence holds water on so many different levels. I think what I think he says in the Select Committee, the problem was with the overturning of the convictions, which we did. We overturned the convictions of probably 700 people, but that was something we were in the process of doing at that point in time, something that never happened in the history of Parliament. So I just didn't think that any of his allegations were ever evidence or ever made sense.
Thank you. Can I turn to Mr. Reed? You tell us in your witness statement that the Post Office was your number one priority as minister, that you spent at least 25% of your overall time and in many periods a much higher percentage focused on the post office, and that Mr. Reid was your principal point of contact at the post office. You tell us in paragraph 44, if we move on, please. Thank you. As time went on, I formed the view that Nick Reid was unable to lead the organisation as it needed to be led. And you say, I repeatedly asked for basic information about management headcount and a plan to reduce senior management headcount and costs. It was like drawing teeth. What information are you referring to? Basic information?
Well, you saw, I think, earlier on, it's in evidence in the pack, if it wasn't shown on the screen, the numbers of people earning more than £100,000. You'd expect, quite simply, the situation today, and this is what I set out at various meetings we had, how did you think those numbers, what the direction of travel of those numbers in a year's time? In 3 years' time, you expect that direction of travel to be significant in terms of reduction of cost. It's quite simple. You'd expect a chief exec to deliver that from one board meeting to the next, so within a month, and that never happened.
You tell us in paragraph 46 that you work constructively with Mr. Reid, you would meet and talk. You thought it might give him a decent chance to see through the reform of post office's culture, but my view was that the guy was being paid lots whilst not doing a very good job. And on the other hand, sub-postmasters were struggling to break even at best. But what, in your view, were the key issues with Mr. Reid's leadership at the post office?
Well, I was always been told that things within the post office, Nick Reid was having problems doing and motivating the team. I think I was told by Lorna at UKGI that the team needed motivated. We need to bring somebody else in to motivate the team, the leadership team. Well, that's the job of the CEO, quite clearly. Reducing central costs, the disclosure of information, to the inquiry, and to make sure that information was disclosed to cases. I think there was at one point a server was discovered, or two servers were discovered that carried lots of information that hadn't been disclosed to the inquiry. There were constantly a number of different issues that were being raised with me, and that all being raised in the media, that gave rise to concern that the organisation wasn't being led well. I think, again, this is set out by the Granthorne report in terms of the limited effectiveness of the board, as it was stated in their report of June 24. Lack of clarity, low levels of trust within the board, no unifying purpose, a lack of succession planning, and we talked before about the processes of meeting discipline and the people agenda. So it was quite clear that the organisation was not being run as well as it should. As I said before, it was a difficult organisation to run, hugely in the public spotlight because of all what's happened to it. So I'm not saying this job was easy, but I think there were some fundamental failings and shortcomings amongst the leadership that meant it hasn't moved forward at the pace it should have done.
Paragraph 45, which is above the one highlighted, you say Nick Reid's pay as CEO was always a running theme. I'm not going to explore that with you. But later in the paragraph at the end, you say it was generally thought that Nick Reid was always on flight watch, even before this. First of all, can you explain, so that I understand, what you mean by he was always on flight watch?
Yeah, I think Henry Staunton had referred to this, and so had my officials at times, that he may leave if he wasn't given more pay. So not just that. That's not the only thing that Nick might consider as a reason to leave. He was massive under pressure, and I think anybody running that organisation would have been. So I understand this was not an easy gig, but I think principally it meant he'd leave if we weren't careful. My response always to that was, well, you know, if that's the case, that's the case, and we'll find somebody else to lead the organisation if he decides to leave.
You tell us later in your witness statement that, quote, my own view was that we should not be moved by the threats to leave. If he wanted to leave, he should leave. Is that right?
That's right.
Can we look, please, at poll 0044-8706? This is a letter from you of April the 21st, 2023, about Mr. Reid's remuneration to Mr. Staunton, the then chair of the Post Office. And you say in the second paragraph, the government continues to be grateful for Nick Reid's work in leading Post Office since his appointment of Chief Executive Officer in September 19. I recognise the significant commitment and effort he's putting in to tackle the multiple challenges that the company is facing. If you just scan the next two paragraphs. And then the large paragraph at the foot of the page. And so this, you refer to a miscommunication between Post Office and government in relation to a backdated pay increase for Mr. Reid. You say that you were content to approve it and that you recognise the significant commitment and effort he's putting in to tackle multiple challenges. Can you help us? Why did you approve the backdated pay increase if Mr. Reid wasn't, as you say now, doing a very good job?
Well, this is fairly early on, don't forget. I mean, I think I was moved from the machinery government changes, I think came into effect in February of that year. So my responsibility for this at that point in time was greater. I think my previous Secretary of State held a lot of the responsibility with the Post Office prior to that. My new Secretary of State, Camille Badenoch, had been very happy to lead me more to it since then. As a general principle, I'll work with anybody until I'm ready to not work with that person. So it's not the case of, at this point in time, we were trying to bring about Nick Reid's departure. It was the fact if he was ready to go, he should go. But we weren't saying at this point in time we should, you know, it's something we were actively trying to do in trying to get rid of Nick Reid. So in that being the case, we would try and work with him on a basis of a constructive relationship. And Nick Reid at this point hadn't had an increase in pairs. I think it says in the letter in 2019. And there was this confusion about when this pay rise was made. And you know, this is a context of some much larger pay rises that Nick Reid and the chair was pushing for. It seemed a reasonable thing to pay this relatively modest increase in his pay at this point in time on the basis he hadn't had a pay rise for 4 years.
Mr. Hollinrake, thank you very much. Those are the questions that I ask of you. Thank you very much for answering them. There will be some questions from the core participant representatives. Sorry. There'll be some questions from the core participant representatives, taking us up to about 12:30. So I think we start with Ms. Page. We've got questions from Mr. Steele as well, and one from Ms. Watt on behalf of the NFSB.
Mr. Hollinrake, hello.
Hello.
I want to ask some questions about the £600,000 offer which was made to those whose prosecutions were held to be an affront to the public conscience. In January of this year, Mr. Ricaldin from the Post Office's compensation schemes had an exchange with the Department for Business and Trade. He started it off with Carl Creswell and Rob Brightwell. They remained copied in throughout the exchange, but the responses came from Beth White. And if I can just summarise what he says in his emails, his argument was that the £600,000 was effectively a flaw in the sense that everyone in the overturned conviction schemes would be entitled to it, and therefore it should be paid to everyone straight away. His point was that those who were able to show that they were entitled to more could treat it as an interim payment, and for everybody else it would just be a full and final payment, but paid out straight away. And his argument was also that paying it out to everyone straight away in that fashion would get compensation flowing quickly, because everyone's entitled to it, everyone might as well have it. Those who still have more to claim thereafter can do so in the time that takes. Do you see his point?
I do.
Well, the response that he received was as follows. I think we will have time to bring it up, so I'll ask for it to be brought up. It's Bayes 400738. And if we could start on page 2. If we could zip down to page 2, thank you. Simon, this is Beth White, and as I said, it's copied to Carl Creswell, Rob Brightwell. Simon, you asked yesterday whether the aim was to get money as quickly to claimants or to get F&F, evidently full and final shorthand, or to get F&F settlements to claimants. Our focus is on achieving the latter. This proposal, i.e. his proposal, doesn't encourage any pace or movement to full and final settlements, does it? Ministers and politicians, as shown in the Select Committee, are keen to take steps to encourage victims getting their full and final settlement as quickly as possible. And then if we go up, he tries one more time, and then on page 1, Miss White comes back to him again. He says, so we hold back funds that we could pay to pressurise, quotes, encourage F&F. And then her response above that. And if I pick it up from the second sentence, you asked yesterday whether you should focus on maximising payments or maximising settlements yesterday. We were very clear that we would like you to focus on ensuring that claimants are able to settle their claims as quickly as possible, as this is what ministers and other politicians are keen to achieve. Neither Mr. Creswell nor Mr. Brightwell stepped in to contradict that. Was the Department for Business and Trade right to say that ministers wanted to effect full and final settlements ahead of getting payments out of the door?
Sorry, would you just ask that question again?
Well, these responses are saying very plainly, we don't want you to maximise getting payments out the door. We want you to maximise getting full and final settlements. That's right. What we're aiming for.
Okay. No, that we wanted both. Will you go back to the original point that Beth made?
Yes.
Where you said 2. In that first sentence.
You asked.
Okay. Yes, that's right. So you asked whether the aim was to get money as quickly to claimants or to get full and final settlements to claimants. She says the focus is the latter. I say the focus is on both. Because the way the fixed sum award works, as you will, I'm sure, know, is that some people, if they'd gone through a full and final settlement, would have got less than £600,000. Some would get more. So, so the point is, it shortens the queue for the others. If you take half the people out of the queue, because one of the problems we heard is getting people heard, that their claim heard, or getting the assessments made, forensic accountants, experts on mental health and physical health, all those things. If you have fewer people having to go through that process, they can get to the claim point more quickly because people have come out of the process. It was never trying to say to somebody, your claim might be worth £1 million, we're going to give you £600,000 to get you out of this. It was a choice people could have, and they could make the assessment based upon their personal circumstances. It was never trying to shortchange people.
Well, let's have a look at how it panned out as far as Mr. Ricaldon was concerned. In the inquiry on Monday, he said this: "I was extremely uncomfortable with that, and I think I'm making my point, articulating of what is the right thing to do, because I didn't want to delay. It seemed to me I was getting an implication to delay redress in order to hold out for full and final settlement. There's an offer there. I want to pay the offer amount, i.e. the £600,000. Then I don't want to feel restricted about not paying that out because I'm only going to pay out if it's a full and final settlement. But they made it clear, absolutely crystal clear, no, Simon, the objective is there, black and white, full and final settlement. So I then had to issue instructions internally to say that those potential interim payments, the government will not approve them now. And they didn't approve them, because they were holding out for full and final settlement."
He's wrong. And if he'd come to me and expressed those views, I'd have explained to him why he's right. I'd listened to him. We had this very similar conversation with the Horizon Compensation Advisory Board. And Lord Arbuthnot made this argument too. He said, well, why can't we just pay it to everybody and then we'll let the people want to claim more? And you can make that argument, and James did. But I said, I'd point to it, if you do that, you will not shorten the queue for people who think their claims are worth more than £600,000. So I pointed out before how we've seen this massive uplift in compensation over the last year, which has got to be a good thing, a fourfold increase to now over £438 million, I think it is. A lot of that is through the fixed sum awards. I think of the latest scheme, of the GLO scheme, of the 306 claims submitted so far, 96% have received offers, 295, 228 have agreed offers, I think 66% of claims through the fixed sum awards. Again, in terms of the new Horizon Convictions Redress scheme, 36 claims have been submitted, 36 offers have been made and paid. So we're seeing much more rapid compensation through this mechanism. That does not stop people going for the full assessment. And if you complete a full claim, which you can do more quickly now because you can get access to the reports now for the forensic accountants and the other advisors you need, as soon as you've submitted that claim, then you get £450,000 as an interim payment.
Why not 600?
Why not 600? Well, it was actually £450,000 as recommended by Sir Gary Hickinbottom as the payment we should make. I can't remember why we said not £600,000 at that time. I guess it because it might, the claim might not stack up at £600,000.
Is it not because it's putting pressure on people to accept the full sum of £600,000?
That was never the intention.
It might not have been the intention. Can you not see that that's the effect?
Well, if I'm very happy to hear from you or anybody else in this room or anybody else outside this room about ways to accelerate compensation to individuals. We felt this was the best way. I'm very happy to have a conversation with you at a later stage why you think, how we think we might do this in a better way, and the advisory board would do that too. But we accepted virtually every recommendation made by the advisory board. Our intention was always to try and expedite claims, full and final settlement or full assessment claim on the fixed sum award, whichever people would prefer.
But this was the message that your department sent to the post office. You asked yesterday whether the aim was to get money as quickly to claimants or to get F&F settlements to claimants. Our focus is on achieving the latter.
Well, that's not true. And I never had a conversation with Beth about that. If she'd asked me how to explain it to her. But definitely myself and Carl Creswell and Rob Brightwell and the Horizon Compensation Advisory Board were all completely on the same page as this is the right way to do it.
one more issue, if I may, Mr. Hollinrake. It's about Herbert Smith Freehills. Now, in January of this year, Post Office told you that HSF were to be phased out. In March of this year, in another meeting, I can give the reference because this is not one that's come up before, we don't need to look at it, Bays 400754, you were told again that the Post Office were looking at alternative providers. Back in July of 2020, in the email that you wrote as chair of the APPG, which we've already looked at, you said on page 2, I'm also very concerned at the involvement of Herbert Smith Freehills, who I understand are advising on the design and implementation of the historic shortfall scheme. The mere fact that HSF acted on behalf of the Post Office in the legal action with the responsibility to minimise losses should prohibit them from taking any role in a compensation scheme. And of course, you were also aware, and you said in that email, of their involvement in the compensation scheme for small businesses after the banking scandals. And the question marks over their role in that case as well. It was an obvious problem, wasn't it, having Herbert Smith Freehills involved in the compensation schemes? And yet here they were 4 years on, and you were still having warm words about them being phased out, alternative providers. Do you regret not doing more to make sure that they were properly exercised from all the compensation schemes?
Yes, absolutely. I mean, you know, I'm sure some very good people in Herbert Smith Freehills. I'm not criticising everybody who works in that organisation, and I'm not saying they weren't trying to do the right thing, but perception is reality. I mean, I think there's a certain part of, as has been said earlier, within this inquiry and by the chair, that we are where we find ourselves, and what's the best way from getting here to there. So, yes, I mean, just tearing out a big lump of the existing compensation scheme and the processes and the legal advice to that scheme maybe isn't the quickest way to get compensation out the door. So it does take longer. Should it have happened in the first place? Absolutely no, it shouldn't.
Thank you. Those are my questions.
Mr. Hollinrake, my name is Sam Steen. I represent a large group of sub-postmasters, also people that worked in post office branches, and we represent people that have been through the Court of Appeal and who have had their convictions overturned, and people that have had their convictions overturned via the legislation. Now, you've mentioned and discussed with the Chair, Sir Wynne, the issue of lawyers being involved and how far and to what extent that assists. You've had experience yourself, am I right in thinking, with a constituent of yours who came to you to discuss their issue, someone that's been affected by the post office scandal, and that they were discussing with you an NDA, non-disclosure agreement, and the potential effect of their signing of the Official Secrets Act. Is that right?
I don't remember that particular case. I did have a constituent in Norton, near Helmsley, who passed away, but I'd never met that individual before what was the case, so who'd been as part of the 555. I may be wrong, but I don't honestly think I did. I think David Davis brought up the point in Parliament about the Official Secrets Act and the implications that had in terms of the ability for people to speak out.
I'm grateful that's of assistance. Sub-postmasters signed the Official Secrets Act on taking up post. As far as I know, they still do so. I'll stand corrected if I'm wrong. And one of the issues that we have come across is that they therefore think that may inhibit them actually engaging with the Post Office, even on such matters as compensation schemes. So that's something that's been raised. We can't go into parliamentary discussions, but that's something that you're aware of that's been raised.
Yes, I'm aware of that.
And we have experience as well that since the legislation cleared those people who had not had their cases taken before the Court of Appeal before, because there's a certain issue regarding people that have gone to the Court of Appeal in the past, but those people in the past whose convictions have been cleared. We've had people contacting my instructing solicitors, Howe & Co., saying, we've got this letter about my conviction. Is it real? Is this the Post Office trying to do something else? In other words, the sheer level of mistrust that is engendered by scandals such as the Post Office also means that people need support from lawyers. Do you agree?
Oh, yes. It wasn't a personal criticism of you, Mr. Steen, in terms of my early remarks on lawyers.
Thank you very much. And I'll put that one on my website. The other issue, of course, and perhaps slightly more seriously, is that people that have been through these scandals, the Post Office scandal, you mentioned the blood inquiry and what happened there, people are damaged, severely damaged. People are damaged in their physical health. People are damaged in their day-to-day ability to cope. People's lives are blighted by lack of sleep, mental health problems, and the like, by the fact that they are forced into poverty, by the fact that they are forced into trying to cater for the day-to-day. Now, you're someone with a long track record of supporting small businesses, and you know that small businesses depend upon everybody working together to run that business within a family, yes?
That's right.
So again, the difficulty for those people left in these dreadful situations is that they do need support from lawyers that are prepared to engage at early stages with either government or what's happened within a scandal in order to provide access way to compensation, yes?
Quite right, yeah.
Right. Let's go one step further. The route through which compensation is often argued tends to go this way before inquiries. What happens is, first of all, there is a need to try and see if the inquiry will seize upon the question of compensation. All of that work is often done pro bono by lawyers such as Howe & Co, myself and others, to try and in fact get the government, if the government is at the root of the scandal, or at least part of it as it is here, to try and engage even on the very basis of compensation. All of that work has to be done on behalf of a large number of people. One or two people lawyers can cope with on a pro bono basis, but you cannot represent people when you're talking about tens and numbers of people that gets up into the larger numbers. There is simply not the capacity for lawyers to do so. So what has to happen is that those lawyers make as part of their campaign the attempt to try and get government to engage on compensation issues. Let me tell you about the next stage. The next stage is when there is a bare acceptance that there might be a need to have lawyers on behalf of claimants, there's then a wrangle about how much they should be paid and about the hours they should spend on such matters. So the next stage is then fighting about how much it is that someone can have. On the other side, what happens is that the government, represented by lawyers, and indeed the Post Office, represented by many different firms of lawyers, is able to fund the payment for their hourly rates as they go forward. So you can see that there is an initial inequality that I'm afraid relates to the claimant side. Do you agree with that?
Yeah, I do, yeah.
Now, you say in your statement this: your appointment, this is paragraph 8, sir, your appointment was manna from heaven to me because it meant I could actually help to fix something important. And you go on to say this: there wasn't a day, night or weekend that went by when I wasn't doing something on the Post Office redress schemes and transformation. So you understand how much hard work is involved in trying to get things moving in relation to these matters. And you understand that that type of work, that day and night work on behalf of people trying to get things done and fixed, is very difficult when essentially it is not funded at all. Do you accept that?
Totally.
Now, you've mentioned the question of working with schemes that don't perhaps on the government side, necessarily have the full engagement of an entire legal team, legions of lawyers working on their behalf. Could you consider this? In scandals such as the Post Office, whereby the government is part of the problem, the government owning the Post Office, the single shareholder, unless the government approaches the question of compensation with a spirit of generosity, there is always going to be a need to have lawyers on both sides, probably, fighting it out. Because without a genuine spirit of generosity in relation to the prospect of payment to those claimants, then essentially there will always be a fight, and the claimants will have to be represented.
Yes.
Now, Sir Wynne is left with the task, which I know he welcomes and looks forward to, which is the drafting of his report. Drafting of this report will take place once all the lawyers stop talking, sometime through this year and into next year. Now, one of the matters that he has to wrestle with are questions of recommendations. We've had by now 2 other reports that touch upon how do recommendations get implemented. The Grenville report and the Blood Inquiry report have both recommended that a committee of Parliament, probably a select committee, continues to oversee recommendations made by inquiries. And I'm not asking you your opinion about that. What I am asking you is this. Do you accept that there is a need for a body, probably such a select committee, to look at the question of how compensation is dealt with where scandals such as this take place, to learn lessons from what's happened in the past, from past inquiries, to consider how better the frameworks for compensation could be set up and managed in the future?
Yes, I totally agree with that. And we tried to kind of replicate that in a perhaps a less formal way with the Horizon Compensation Advisory Board. I wasn't seeking to criticise lawyers, the actual lawyers on either side of the process, actually. And, you know, we would never be here if it hadn't been for lawyers. This never would have come to light. And I fully understand that this is all done, as you say, on a pro bono basis. And as I say in my statement, this came to light because of Paul Marshall, and who was supported by Flora and lots of other people who did a fantastic job on a pro bono basis to bring this to light. So, I mean, in many ways, you're the heroes of the hour in terms of making sure this came to light. I'm not just trying to be nice to you because you're asking me difficult questions. But my point is really not that you shouldn't have lawyers on either side. In fact, you should have somebody in the middle. That's really my point. And I think this is what the National Audit Office has said. I don't think a select committee can ever play that role. It might do some oversight, or an advisory board can do some oversight, but you need somebody right in the middle who's not incentivised for this process to take longer. Because you and I would probably recognise that if you work for a large legal company, you've got an amount of hours to bill on a monthly basis. Maybe sometimes some of those processes take longer than they might. So but if somebody in the middle can say, no, I'm not worried about that small element of this claim or that particular legal point you're raising, I'm taking a view on this exactly in the way you phrase it, so that it is generous and seen to be generous to the claimants who are involved in the scheme. I don't think you can do this just by lawyers arguing on either side. That's my point.
Yes. What I'm saying, the spirit of generosity really must come about because it is in situations such as the post office scandal, whereby at the heart of it there is a recognition that harm is being caused. That's the starting point for this inquiry. And so when we're talking about the spirit of generosity, it is in fact the balance. It's the repair or an attempt to repair that the harm that is being caused by one actor, in this case the government and its single shareholder status in relation to the post office. So it's about acceptance of this is what we've done. We're sorry about it being done. We're not only sorry, but we're actually going to pay up. I'm going to make sure we pay up with as open-handed as possible, bearing in mind public finances. That essentially is what should be embraced. Do you agree?
That's exactly what should happen.
Thank you, Hollinrake.
Thank you.
Ms. Ward.
Thank you, thank you, sir. Good afternoon, Mr. Hollinrake. I'm over here.
Good afternoon. Hello.
Thank you. We have this difficulty every time I ask a question.
See you fine.
I'm going to ask a question on behalf of the NFSP, and I'm going to call up a document, and I'll give the number for that. But you might recall that on the 8th of January this year, just after the ITV drama Mr. Bates against the Post Office, the NFSP Chief Executive Callum Greenhow wrote to you, and that letter is WITN 00370106, and I'd just like to call that up. And if we scroll to page 2, and it's about halfway down the page, the paragraph that begins, postmasters are justly and rightly highlighting their concerns over the robustness of Horizon today, with the NFSP repeatedly calling for the system to be externally audited to ensure that nearly 5 years after Justice Fraser's Horizon Issues ruling, that the system is robust. Everyone, whether postmaster, assistant or Crown Office employee of the Post Office, still use Horizon today, and collectively we have to have confidence that the system works as it should and does not have bugs, defects or errors that secretly affect branch office accounts, government, as the sole shareholder, should be ensuring on behalf of the general public that this is the case. We take that document down. The inquiry has also heard, I'm not calling this up, but I think you've referred to it in any event, has also heard about the results of the YouGov survey for the inquiry. That's EXPG 000000. I think it's another 0 and 7. And that indicated that 49% of respondents using Horizon at present were net dissatisfied with Horizon, compared to 25% who were net satisfied. And in addition, 57% of respondents had experienced unexplained discrepancies within the last 12 months. And in addition to that, the inquiry has heard evidence about the delays to the new branch IT system, NBIT. It's years behind now and millions over budget, and it's possible, it sounds like, that at the Post Office it may have to look even beyond NBIT. But certainly it's unlikely the Post Office is going to move away from Horizon anytime soon. So what I wanted to ask you was, would you agree that an external audit of the Horizon system is necessary? In other words, something that's completely independent to report back to everyone with an interest, involving and including postmasters?
That sounds very sensible to me.
To your knowledge, and following on from that letter of January the 8th this year, and appreciating that your knowledge may extend only to the 4th of July of this year, in light of this letter, has there been any proposal that you know of within Post Office for the current system to be externally audited?
I don't think that's something that we ever directly discussed, although we did discuss some of the concerns about ongoing discrepancies. And I mean, there are postmasters are dealing with cash every day. There will be discrepancies for it, bound to be some discrepancies. I think what the problems with Horizon were not just IT problems. They're also the approach of the Post Office in terms of their willingness to prosecute and the willingness to think the worst of postmasters. And it's my understanding that the Post Office take a completely different approach to this. Instead of an adversarial approach to some money missing, it's an inquisitorial approach, which is, okay, you know, certainly giving the postmaster the benefit of the doubt, which you would expect to happen in this kind of network. So I understand that to be the case. It wasn't the case that anybody came to me when in my tenure as Post Office Minister to say this person's been taken to court. In fact, the Post Office don't no longer take forward private prosecutions, but he's been taken to court on the basis of evidence from a Horizon or something that is. So I never heard those concerns either from the NFSP or from others in terms of this was a live problem ongoing about these issues about discrepancies being then taken forward in terms of something along the lines of what happened with Horizon previously.
Although that point is being put in that letter, you would accept.
Yeah, and I do have no problem at all in an audit of the system. Clearly, I'm not the decision-making minister now, but that would seem sensible to me. It was the first time I'd seen the YouGov survey in terms of the pack that I read over the last few days. But on that basis of lack of trust amongst the network for that system, I think that would seem eminently sensible.
Okay, just to tie that off, can I take it from what you've said that the government, in your time, up to when you concluded your role, that the government as a sole shareholder hadn't asked the Post Office to conduct such an audit?
I don't remember us doing that, no. But we did ask questions about the approach that Post Office is now taking where there were discrepancies.
Thank you.
Can I detain you for 5 minutes?
Yes,
I think that's
certainly.
it, Mr. Hollinrake. It may be that I will need to form a judgment about the pros and the cons of the fixed offers that operate. All right, I'm not sure if I will need to do that, but just in case I do, since you were obviously very influential in their introduction, I'd like to get your view as to what are the pros and cons.
Yeah,
all right. I think I can identify as two pros: speeding up the payment of compensation, yeah,
Yep.
and in all probability, significant savings in legal and expert costs. Yeah.
Yep, that's true.
Can you identify other cons for me? Sorry, other pros for me before we get to the cons?
Well, as I said earlier, some people who would have got less than the fixed sum award will now get.
Well, that might be thought to be a con. So let's come back to that in a moment.
Well, no. Okay.
Can we try and do it in
Okay.
that way? So we got speed of payment, and as I say, I can imagine that if you got an actuary or an accountant on it, they might be able to justify value for money in terms of saving in legal costs and all the rest of it. So those are what I see, at least, as the two major benefits of the scheme.
Okay.
Okay. The cons actually relate to the recipient, because it's not a con for Wyn Williams if my true claim is worth £5,000, but I get £75,000.
Oh.
It's a windfall.
Yeah, that's right.
Yeah? But it's a con also, isn't it, for the public at large if that happens.
I mean, the public at large pay more, you mean, in terms of the taxpayer? Yes.
Well, and there's a point about the fairness as between claimants.
Oh, you could definitely argue that some people would feel, well, you know, that person's getting more than they should, or the same as me. That person's only due £5,000, and I've got £75,000, and I was due that, and they've got the same as me. You could argue that.
Yeah, and then the other part of that thinking process is that people who are, shall we say, claiming £85,000 or £90,000 might well feel pressured into taking £75,000 because they know that if they don't accept the 75 at a point in time, it's lost forever, as the current scheme currently operates.
You could argue that.
Well, I think I would argue it if I was a lawyer.
I'd argue differently. I mean, I would say there is, of course, a case for that. So people might decide to take a view. And can I say, nobody's saying those people shouldn't have legal advice or other advice before they decide to take that.
But the point I'm
yes.
going to come to is this, that in normal litigation, okay, set aside cost consequences, if you, the government, make an offer in a case of £500,000, then, except in those very rare cases where you withdraw it completely, it's always available to be taken, right? In this scheme, if you don't accept the 75,000 or the 600,000 at a particular moment in time, that sum is lost forever and you're on risk of getting less. Is that fair to describe as a downside?
Well, that would depend on the rules of the scheme. I'm not saying...
Sure, so that's my last question to you.
No, I don't say for a minute that if somebody decides to go down the full assessment route and then is only offered, let's say, £60,000 rather than the 75,000, would you give them the 75 anyway? I think you could
I was
argue that
being a
case.
bit more generous to the post office or the government, and simply going to suggest that why is it you've got to make a once and for all choice at a moment in time, as opposed to being able to say, well, look, I've now gone down the full route, but I realise that I'm on risk, and so I want to draw back and take the 75,000. What's wrong with that?
No, I don't think potentially there is anything wrong with that, and that could be a feature of a future scheme. And we had that discussion ourselves internally. Like I say, it was never the case. I don't care how much this compensation scheme costs. Of course, we've got to have an eye on public money, but what is fair is fair. So if it costs, it's now the envelope, I think, is 1.8 billion. I don't care if it costs 2 or 3 billion. I said this to James Arbuthnot and to the officials. It was never a case of trying to save money. It was always a case of trying to expedite and accelerate the amount of compensation that goes to individuals. We never try to shortchange anybody, and the scheme should never try to do that.
All right. Well, armed with your views, I'll ask Mr. Creswell and your successor minister in due course what they think of that. All right. Very good. Thank you. Thanks very much, Mr. Hollinrake, for your assistance to this inquiry.
Thank you. My pleasure. Thank you.
Thank you. So can we break until 1:30, please?
I've heard of truncated lunchtimes, but even by your standards, Mr. Beer, that was pushing it a bit. Yes, 1:30.
1:30, thank you.
Yeah.
Thank you, sir.
Mr. Blake.
This afternoon we're going to hear from Mr. Creswell.
Yes.
I do solemnly,
sincerely and truly,
declare and affirm
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Can you give your full name, please?
It's Carl Philip Creswell.
Mr. Creswell, you should have in front of you a bundle containing 2 witness statements that you have produced. Could I please ask you to turn to the first witness statement? That should be dated the 2nd of October 2024, is that correct?
It is.
Could I please ask you to turn to the final substantive page, that's page 71. Can you confirm that that is your signature?
It is indeed.
And can you confirm that that statement is true to the best of your knowledge and belief?
I can confirm that.
Thank you very much. That has a unique reference number of WITN 117-30100 and will be published on the inquiry's website. You then also produced a second witness statement. You should have that in front of you, dated the 22nd of October 2024.
I do.
Could I ask you please to turn to the final page of that statement? That's page 20. Can you confirm that that is your signature?
It is.
And can you confirm that that statement is true to the best of your knowledge and belief?
It is.
Thank you very much. That witness statement has a unique reference number of WITN 117-30200 and will likewise be published on the inquiry's website. But by way of background, you are a civil servant and have been since 1998, is that correct?
Correct.
You have a background in a variety of roles, including Director of Better Regulation, and you are also involved in, for example, the establishment of the Competition and Markets Authority.
Correct.
You are currently the Director of Post Office Policy and Engagement and Business Engagement, and you've been in that role since April 2019.
That's right.
Thank you very much. Mr. Creswell, I'm going to start by asking you just some general background about your department and your role within it. In your statement, you touch upon changes that took place just before you arrived, I think in 2018, to the department's role as vis-a-vis the UKGI. Can you assist us with that briefly?
Of course. So you're right. In 2018, there was a step to move some more Parliament-facing functions out of UKGI into the core department. So that started with dealing with correspondence and parliamentary questions and that sort of Parliament-facing activity. In about March 2019, I was asked by Alex Chisholm, who was then the Permanent Secretary, to move into a newly created director role within the core department. And the intention of that was to create a strong policy team to sit alongside the UKGI team that was being run by Tom Cooper. And that was a broader function than just dealing with parliamentary questions and so on. It was much more about what are the government's policy responsibilities vis-a-vis the post office and also issues of funding and so on. And UKGI's role narrowed at that point to be more focused on the commercials around the business and appointments issues and remuneration and so on.
I think you've said in your witness statement, it's effectively setting apart the policy direction from the corporate governance and the financial advice roles.
That's correct. And there were various motivations for why that happened, which I could expand on if you were interested.
If you could briefly, yes. Please.
Okay. So at the point at which I joined and I talked to both Alex Chisholm and then Kelly Tolhurst, it was clear that on the back of the Mr. Justice Fraser and now Lord Justice Fraser judgment, there were quite significant concerns at ministerial and PermSec level about whether we were providing adequate support to ministers on post office related issues. I think there was a bit of a loss of faith from Kelly Tolhurst in the support that she was getting from UKGI. And so my role was to carve out space for a new team, and I was given license to bring in more capacity in order for me to create that stronger team that would act as a bit of a counterpoint and a balance with UKGI.
Is it easy to separate out those two distinct roles?
I have found it to be so, but over that first year, towards December 19, we had to do some work through setting out, ultimately in a framework document, the relative responsibilities of the different parties. So the department, then BEIS, and the Post Office, and UKGI. There is an interaction between some of our responsibilities, but I think the delineation is fairly clear. So I know you will be hearing from Lorna Gratton. She and I work very closely together, but we don't overlap in our areas of responsibility. She is clear that I am the one who is responsible for supporting business cases that go to Treasury about the money that the company needs. I am clear that she supports the recruitment of chairs and CEOs and others to the company.
In terms of briefing a minister, do you take sole responsibility for that, or do you both brief ministers?
It depends upon the occasion and the topic. So I do see Gareth Thomas, my current minister, more frequently than Lorna, but Lorna does also come and join meetings on occasion with the minister, depending upon the topic. Later this week, the Secretary of State, Jonathan Reynolds, is seeing Nigel Railton for a catch-up conversation, and we will have both someone from the policy team and someone from the UKGI team there, because there are interests on both sides of our fence that need to be represented. Over time, in my tenure, over those 5 years, I have taken on a much bigger role in relation to redress than I had in the early parts of my tenure, where UKGI did a lot of the work on, for example, the Horizon Shortfall Scheme. And so my conversations with the Minister about redress don't tend to now have Lorna or UKGI present in the room.
Thank you. We'll go into details in due course today about various schemes and various developments, but just looking at that separation broadly and looking at the evidence that you've heard throughout this inquiry, do you think that current division is right? Do you think it should change in some way?
I think it works well, actually. Thank you. I think we have got a good relationship and a clear delineation of responsibilities. And obviously, I am not running the post office, and I'm not attending the post office board, and I'm therefore quite dependent upon UKGI's expert analysis on commercial issues, but also on the flow of information from the post office through Lorna and her team to me and to my team, because if that relationship didn't work, I would have a much less strong grip about the issues that were bothering the post office board, for example. So I say that by way of an example about what I think works well. I suppose in theory, if the relationship between the two teams or myself and Lorna didn't operate effectively, then that would be a challenge. But I think that would probably be inherent in any structure, since I don't think it would be sensible for me to sit on the post office board. That is Lorna's role as the shareholder representative.
Thank you. In terms of the time that you spend on post office matters, you've said in your witness statement that you spend, I think, 80% of your time on those matters, and you have a few other matters outside of that role.
That is correct as of now. In the past, though, over that 5-year period, I had a much wider set of responsibilities, including during the COVID period of 2020 to 2021, working with the retail, hospitality and wedding sectors, and other responsibilities that I had. But over a period of time, particularly as our role in redress has grown, with DBT running 2 of the compensation schemes, I've narrowed my brief to focus primarily on the post office. And in the coming months, actually, I expect to lose my business engagement responsibility and focus exclusively on post office issues.
You've explained that you have 70 staff within your team. Is that because you're particularly busy dealing with redress matters? And will that stay the case, or will in due course that team wind down to some extent?
So if you take a sort of a very long-term view, I would expect that team to reduce in size quite significantly, yes. But there is a lot of work still to do on redress, as no doubt we will go on to discuss. And when I joined in April 2019, I had 2 members of staff. So we're actually above 70 staff now as a result of recent recruitment. But since probably the end of last year, I have doubled the size of my team to respond to the need to legislate to overturn 900 convictions, to work with people affected by the capture system, to set up and then run the Horizon Convictions Redress Scheme, as well as then the GLO scheme.
Thank you. I'm going to take you through the early months of your time at the department and focus on the group litigation. Could we please bring up onto screen UKGI 409785, please? This is an email chain from May 2019, so your first month really in the role. If we scroll over the page, please. If we could scroll down slightly. A note here is being drafted for the Minister, that's Kelly Tolhurst at that stage. You are sent an email by Tom Aldred, who's part of the UKGI team.
That's right.
We see here, I think it's a combination of his draft and also your changes to the draft in a slightly lighter text.
Yes.
I'll just read to you a few passages from there. He says as follows. He says, as discussed, Tom has shared a draft note to go to Kelly, which I've pasted below. What do you think? Jess has confirmed that she's happy to pass to Kelly as an email rather than a submission. And the draft is as follows. I gather you mentioned a couple of things to the team after the meeting with the post office yesterday, one being what happened at the board in relation to the legal advice. The other, that you're concerned about the company's approach to forecasting the potential size of liability. And under heading of litigation, it says, on the legal front, I think we've reached a sensible position with the post office changing its legal advisors and seeking a more conciliatory approach. Like you, I've been concerned about their approach. I wasn't happy with the meeting the company had with you and Alex last October. That was followed up by a very critical ruling from the judge a few months later, following when I spoke to Tim and Paula to say that I felt there needed to be a major change of approach. Our interaction to the legal team at the post office wasn't limited to the litigation. In general, we found their chief counsel wasn't easy to deal with, and I passed feedback to the management and Tim on various occasions. Things had come to a head after the common issues judgment when it became totally clear, I think to everyone on the board, that there needed to be a change of personnel. This led to Jane McLeod, chief counsel, leaving the company. In terms of the atmospherics when you first joined the team, what was the feeling towards the post office's approach to the litigation?
So Kelly Tolhurst was very frustrated on a number of fronts, to be honest, when I first met her. She was very frustrated about what had happened. I think she felt embarrassed, as I think she probably said in her own evidence, about the outcome, because I think that Al Cameron and Tim Parker had been much more optimistic about the likely outcome for the trial, and I think she felt she was a relatively new minister, and I think she felt on her watch something awful had happened and she hadn't known that it was coming. She felt that the company was failing to give her information that she needed to fulfill her responsibilities as the minister. She also was very angry with Tom Cooper, which is part of the backdrop to this email and my advice back to him. And so she had lost confidence, I think, in the whole arrangement and setup. So within that, I think you're right, she was unhappy about the approach that was being taken by the post office and the sort of we are being sued rather than justice for postmasters approach that you could see evidenced, and I could see that myself from talking to the post office in my early days, talking to people like Mr. Cameron. And I think that left her feeling a bit vulnerable, but also trying to work out what should happen next.
If we scroll up, please, we can see your response. You say, it's the bottom of page 1 into page 2. Thanks for sharing this with us. I've set out my thoughts below in the spirit of trying to help you land your message as well. For my own, the tone feels a bit defensive to me. So I've suggested some changes below. Kelly seemed to partly be sparking because she thought that she was hearing something different yesterday, decision by consensus, compared to what she heard during the recent phone call. Coup. Can you just assist us with what's meant there?
Of course, yes. So I also worked with Kelly on other areas of responsibility, such as on the retail sector. So by this point, I'd already established what I thought was quite a good relationship with her. Tom Cooper was holding the role that Lorna Grattan is now holding, obviously, in UKGI.
Sorry, if I could just pause you there. I think I'm getting in trouble with the stenographer.
Is that too quickly?
If it's possible,
too quick?
Speak slightly slower. That would be very helpful.
What was happening here was I was trying to help Tom navigate through a tense situation with Kelly Tolhurst, where I had been discussing with her for a period of time, and so too had the Permanent Secretary, what changes were needed to respond to the Minister's concern about the Post Office. And this whole email chain occurred in a situation where Tom Aldred, who worked for Tom Cooper, and I had met Kelly, and Kelly had aired various concerns. Tom Cooper then returned, I think, from leave or absence of some kind, and wanted to go to Kelly and have a conversation with her because he had heard secondhand that Kelly was a bit frustrated. My judgment was that what the Minister wanted was for us to move beyond some of the previous conversations that we had dealt with without Tom Cooper there, and that it would actually undermine our ability to get more confidence back into Tom Cooper if Tom wrote this sort of email that picked up things that actually Kelly had reached a conclusion on, and that it was better to sort of leave some of those issues as they were and then move forward. Would you like me to say a little bit more about the coup question?
Yes.
So I think this was a question of slightly different language between the two of them. Tom Cooper had said in a previous meeting to Kelly, look, it's great, the Post Office has decided to change its legal team following on from the judgment. And in order to, I think, make it clear that he had played a significant role in that at the Post Office board, remembering that this was at a time when Kelly felt that the government representative had not been sufficiently pressing the Post Office for a number of months, he described it as a coup, by which I think he meant this was a victory for common sense in terms of getting the Post Office to shift its approach. She took that, I think, to be a sign that things were still not right in the Post Office board and that there was a problem. And I think there was this sort of slight disagreement of language, of talking across each other, which was slightly typical of their relationship at that point.
And I think you addressed that here. You say, I explained that you had meant coup in the sense of a victory for common sense, but she still seemed concerned. So my advice would be to emphasise that we have got to a better place, give the details of what happened, and explain that you're going to be keeping a close eye on them going forward. I also think it would be best to leave out the reference to the leadership of the company. Strictly speaking, she didn't raise it with us in those terms last night. What she said was that she remains nervous about the Post Office approach. I also think Kelly is unlikely to want to discuss it at this stage. I feel that we've made some good progress this week, etc. What was the feeling towards the leadership of the company at that stage?
Well, I think Kelly was quite frustrated with both Tim Parker and Al Cameron. I think she found their approach quite patronising and quite bullish. And I think she felt, and I must admit I had some sympathy for this, that they were slightly in denial about the magnitude of the judgment, and they still hoped at this point, remembering it was May 2019, that the Post Office would be successful. I can't remember whether the recusal attempt had been rejected by that point or not. It had started before I joined, but concluded shortly thereafter. But the appeal requests were still in play, and I think she felt that the leadership was still somewhat in denial.
Thank you. If we turn, please, to page 1, and the final email in that chain that I'll read to you. It's the response from Tom Aldred. He says, for my own part, although she didn't say explicitly that she had concerns with the leadership, I thought it came across pretty strongly in her remarks and in her questions about how we appoint the board and her desire to attend. While I'm tempted to hope it blows over, on balance, I'm more attracted to addressing it head on. If she really doesn't have confidence in the leadership, this has the ability to make everything else a lot more difficult, and we need to understand what's driving her concern. So did the Minister at that stage have concerns about the leadership of the Post Office?
She did have some concerns, and she did suggest that she would like to join the Post Office board and actually sit on the board, which is slightly unusual in corporate governance terms. I felt that Tom Cooper approaching her and saying, let's have a conversation about the leadership, given that she had quite a level of concern about the support that she got from him, I felt wouldn't be that helpful, because I felt Tom would probably go in and say how great, that the leadership were fine and that we didn't need to change the leadership. So my judgment was the best thing to do to support the Minister at this point was to try to dissuade Tom from going in heavily on this issue, given that I actually felt that she had become more comfortable over the period up to May 2019 with where we had got to, but still wanted us to do further work on issues like information sharing from the Post Office.
And we'll get on to a couple of those emails that say exactly that. If we could turn to UKGI 409832. We see on page 2 over to page 3 an update from Ben Fote, General Counsel at the Post Office, providing an update regarding the permission to appeal decision of the Common Issues judgment, and also in relation to costs. If we can see over the page, thank you very much, it says, we were in court today before the managing judge to seek permission to appeal the Common Issues judgment. and determine how the cost of the common issues trial should be treated. If we scroll down on permission to appeal, he says, as expected, the judge didn't agree. There was a real possibility of Post Office successfully appealing his common issues judgment and did not give us permission to appeal. If we scroll down, he addresses the costs, and he says the judge exercised his discretion and awarded the claimants their costs of the common issues trial, rather than reserving the question until later in the litigation, when the full impact of the judgment would be determined. If we scroll up, please, to the bottom of page 1, we see an email from yourself to Tom Cooper. Thank you very much. You say, thanks very much for sharing this all so promptly. I suspect that this latest development will strengthen Minister's concerns about the Post Office's approach to litigation. So I'm trying to get around the scale of the implications. My reading of it is that the decision not to let them appeal and require going to the Court of Appeal is completely straightforward, and anything different would have been a surprise. But the costs order is the worrying bit, because it will increase the liability for the Post Office beyond any damages. Presumably that's only for this first case, but it might set a worrying precedent for the future. You say, do you think there's an argument that it should change our assessment of whether it's desirable for the Post Office to consider settling at this stage? Just pausing there, what was the position within your department about settling at that stage, and what was your own personal opinion?
Yeah, so within the department, Alex Chisholm and I were both clear that a settlement would be needed, and there was the right course of action. My own personal experience of working in another department, the Department of Education, was that a settlement when there was a legal dispute against a public body is a sort of classic thing that you would do when you have been found guilty. So we were all of that view. And to be fair, I think Tom Cooper was in that space as well. I think the company was probably still hoping that it would, that people would see right and that the judgment would be overturned in some ways. And my reading of the judgment was, and I wasn't and I'm not a legal expert, but the costs order was an indication that the Post Office was very unlikely to be successful in that course of action in trying to get the judgment overpeeled. So for me, this was a flashing warning light on the dashboard saying, no, there's no way that their optimism is going to work out.
And you say that even though the new lawyers seem to be saying that the Post Office has a case, it feels to me like this is going to run and run and perhaps not end well, given what the judge has already said. If we scroll up, we can see the response from Mr. Cooper. Thank you. And he says, the judgment itself isn't a surprise. If the Court of Appeal turns it down, that would count as a real setback, probably the biggest so far by some margin. Were there real concerns at this stage about how the litigation was being run or continued to be run?
There were a lot of concerns about how it had been run up until this point. I think prior to my arrival in post, Sir Alex Chisholm had taken some advice, or he'd read some of the advice about the strategy that was being taken by the company in seeking to appeal. I think there was a concern about the recusal, attempt, but that was again prior to my time. I think people were dubious that the appeal would succeed, but felt that it was a judgment for the Post Office Board about whether to request that appeal. My view was, look, this looks like you're going to lose, and you might as well accept that sooner rather than later and then get on to settling, because part of my responsibility is to support the current company with all the current postmasters, as well as dealing with the historical liabilities. And to my mind, you needed to get quickly through that sort of settlement in order to help the company move forward. I think Tom Cooper also would think that settlement would be a good idea, but it was his team in UKGI that had been providing advice about the litigation prior to my arrival, and even sort of from now onwards, a lot of the submissions were written by UKGI, but with input from me.
Thank you. And moving on shortly in time, can we please turn to Bayes 40830? We're now on the 4th of June 2019. There's a readout from the industry meeting on the Post Office. If we turn to page 3, please. Under the heading Litigation, it says Secretary of State, backed up by Kelly, so that's the Minister, has serious concerns about the direction of travel of the litigation and the Post Office's handling of it. Reference the first judgment and particularly the recusal application as evidence of poor judgment of the board. Were the concerns as broad as the board itself rather than those two individuals who you've already mentioned?
I wasn't present in this meeting, so I didn't actually hear that conversation. And I didn't actually meet the Secretary of State at that point to discuss it, Greg Clark, but I was talking to Kelly. And I think she was concerned about the board more widely, and I think that's why she wanted herself to join the board.
It continues, Secretary of State gave a clear steer that he wanted the department to be on the side of the postmasters. He said it felt like there were shades of a windrush regarding the potential for a number of injustices to come out, and wants a strategy on how we can take this forward. He wants to resolve this quickly, given the damage it's doing to the reputation of the Post Office. Kelly reiterated her concerns about the effectiveness of the board and about the information shared with her. She pointed to the fact that the Post Office hadn't done any detailed work on the potential liabilities from the case as a concern. If we scroll down, we can see action the Secretary of State has asked for. He's asked for a Bayes strategy to ensure the litigation is settled quickly and put the department on the side of the postmasters, resolve the CEO pay issue so that we can recruit the best candidate, and consider how we deal with the ongoing management of the ministers have on board performance. Could we please turn to UKGI 30010212, please? There's then a meeting with Tim Parker and Al Cameron on the 24th of June 2019. That's a meeting with yourself, is that right?
I was present at the meeting, but it was actually for Kelly Tolhurst to meet those individuals.
Thank you. So where we see the internal attendees, that's in addition to the Minister?
Correct. So where it says, for example, in the section below, in response to your letter of the 29th of May, it wasn't my letter, it was Kelly Tolhurst's.
Thank you. If we turn over, please, to page 2, it sets out the Post Office's approach to ongoing litigation. And it's suggested as follows. It says, please express your dissatisfaction with the current status of the litigation and invite the Post Office to present details of their strategy. At the second bullet point, please provide the below steers to the Post Office reflecting the options agreed by the Secretary of State. The department's preference is for the Post Office to pursue early settlement of the case. The Post Office should carry out a project on how to structure and operate a settlement, including a fund which would subsequently assess claims and award compensation according to pre-agreed criteria. We see the beginnings of what became the redress schemes, or is this simply focused on the settlement of the litigation vis-à-vis the litigants?
So it was a major step towards the settlement in December 19 with the GLO group. Within this comment is the hint at the sort of redress schemes that we have now set up. And I must admit, I had forgotten until I saw this paper that idea had been floated at the time. I think the Post Office's lawyers have been looking at various options. My memory is that the idea of a fund that would award out compensation was rejected following conversations with the claimants in the GLO group on the grounds that actually what was needed was early settlement and money to go to the GLO claimants quickly to be distributed by Freeths or whoever through a formula, rather than the start of a claim-based system, which is more like we have now. There's a missing piece of the jigsaw between the document you've just shown me and the previous one, which was the actual Bayes advice, which was requested by the Secretary of State that responded to some of Kelly Tolhurst's and the Secretary of State's concerns, including a long list of options, the most radical of which would have been to have replaced the leadership, but the Secretary of State decided not to do that.
Thank you. So one option up in the air at that stage was replace the leadership. This is a rung or two down from that, is it?
In timing terms, yes, that's correct. I think I heard Kelly Tolhurst talk about this when she gave evidence here before as well. I think the view was taken with the Secretary of State that a new CEO was needed, both a permanent and a new CEO, i.e. probably not Al Cameron, and that in that context, and that obviously led to the appointment of Nick Reed later that year, replacing the chair at that point probably wouldn't be a good idea because you would create more instability at a critical time when the company needed to move on.
Thank you. If we could turn to Bayes 301130. There's another meeting with Tim Parker in October, 31st of October 2019. You attended that meeting, you're listed there as an attendee, is that correct?
I'm definitely listed there, and I'm sure I did attend, yes. Yeah, this was for Alex Chisholm.
Thank you.
With Tim and Tom and me.
If we scroll down, there are issues listed there. Litigation. Judgment in the Horizon trial is expected in early November, following the discovery that the Post Office had failed to disclose information, known error logs, that may provide a fuller account of bugs in the Horizon system. While this appears to be Fujitsu's responsibility, Justice Fraser is likely to be highly critical of the Post Office. A decision on the Post Office's application to appeal the Common Issues trial is expected on the 12th of November. If we go over the page, please, there are issues to be raised with Tim Parker. The first of those is culture. Paul's culture needs to change, and as the shareholder, we expect the chair and board to be leading this. The leadership's decision on the litigation, such as the failed expensive recusal attempt and the proposal to pay bonuses in full, appeared tone-deaf and complacent. By this stage, it seems very strong criticisms of the way that the Post Office is being run. Is that fair?
Yes. The bonuses incident over the summer, which again sits between some of the earlier documents and this one, caused great frustration for Alex Chisholm and others in the department, because it was a classic example of the company failing to acknowledge that they had harmed so many postmasters through the horrific scandal and were still trying to pay themselves large bonuses.
Thank you.
And it took Alex quite a lot of effort to persuade them not to pay those bonuses in full.
One final document on the litigation, that's UKGI 3047866. We're now in April 2020, so we're now a year into your role in the department. I'd like to start on page 3, please. It's an email from Minister Scully's private office to yourself and others. Please find attached a letter from Tim Parker to the Minister regarding the Post Office's financial exposure resulting from the number of cases potentially being referred from the CCRC to the appeal courts. If we scroll up, we can see a response from yourself to the Permanent Secretary and others. And you say you should see the attached letter, which provides more detail on the additional past prosecutions the Post Office has identified. The letter includes an eye-watering maximum liability that they may be exposed to. Minister Scully is meeting the Post Office's leadership for the quarterly shareholder meeting tomorrow afternoon, and we are briefing him to express disappointment and put pressure on the Post Office to ask for more information ahead of our putting advice to ministers. Is the picture getting somewhat worse by this stage?
Yes, and I think Sarah Munby touched on some of this in her evidence yesterday. I think we knew after the Lord Justice Fraser judgment that the Post Office had acted awfully. We didn't really realise, as much as probably we should have done until the Hamilton judgment, quite how badly the company had behaved. And even prior to that judgment, the advice we were getting was that they might not lose on both limbs of the of the case, and so the sort of there was still some uncertainty about what the outcome would be. And then we have a letter from Tim Parker saying that the liability that they would be bringing to government that needed to be funded was of an order of magnitude of around 700 million in a world in which they're their revenue is about 800 to 850 million. So it was, it was eye-watering because of the sheer scale of it. But no, you're absolutely right. And the disappointment from ministers probably reflected that sense of, oh goodness, it's even worse. And this sort of direction of travel continued over a period of time as more stones were lifted up and more problems of past behaviour were discovered. With the help, to be honest, of Nick Reed as the new CEO, helping turn over some of those stones.
If we turn, please, to page 1, we have another email from yourself. If we scroll down, please. And you say as follows. You say, the Minister expressed his disappointment, as you can imagine, and emphasised how important it is for the Post Office to share information with us. Was there a concern about a lack of transparency from the Post Office?
I think the Minister was concerned that the company could perhaps have shared more information about this in advance, probably because the outcome that was being pointed at was so negative. I think he felt they should have said in advance that this was the likely outcome. I'm not sure how completely fair that was, because the Post Office was saying it is possible that we might not be successful. Although, as I said earlier, they did not say we're likely to lose on both limbs and, be found guilty of malicious prosecution or whatever. So, yes, I think I could have just said yes.
Well, just looking at the picture then, as it presented itself to you within or by a year into the role, it appears that there were real concerns about the leadership of the company, including as wide as the board. Is that right?
Actually, by this point, the concerns from ministers weren't quite the same. So, yes, Minister Scully was disappointed that the Post Office hadn't shared more information about the likely liability in relation to this court judgment. But Nick Reed had joined at the end, about November from memory, of 2019, and there had been some turnover in the board as well, and Kelly Tolhurst had moved on, and Paul Scully was now meeting regularly with Nick Reed. So that earlier level of heightened concern from Kelly Tolhurst had been sort of passed by, and I think the minister was less, this minister was less of the view that the whole board needed to be replaced. And of course, the settlement had been reached in December 19, albeit that it then turned out in 2020 to have been much smaller from the postmaster's perspective than we had frankly realised.
Irrespective of that, was the general feeling that this was a company that had handled the litigation badly?
Yes.
It was a company of which your department had concerns about the culture within the company as well. We saw that reference in that meeting with Tim Parker. Were those cultural concerns present as at April 2020?
They were, although what I would say was that when Alex Chisholm sat down with Nick Reed for introductory conversations, that was the central topic of conversation between them. So Alex was effectively saying to Nick, one of your biggest challenges is to grip the culture. And they talked about different ways of assessing what the culture was like, getting some externals in to come and give a view to enable Nick to put in place changes, including heightened engagement with postmasters that would help respond to some of the cultural challenges that were there. So I suppose what I'm trying to say is it wasn't a sense of resignation about, oh, the culture is awful, it's never going to change. It was high on the agenda for issues to be addressed.
Would you say that there were serious issues with the company to be overcome by that stage?
Oh, yes.
To be addressed?
Oh, yes. No, I mean, throughout most of my time working with the Post Office, there have been quite serious issues.
In those circumstances, the question might be asked, why was it felt appropriate for the Post Office to be charged with some of the redress and compensation schemes?
Yes, of course. No, it's a very good question. The only redress scheme in play at this point was the Horizon Shortfall Scheme, then called the Historical Shortfall Scheme. That was, as you probably well know, set out, delineated, drawn in the settlement deed for the GLO order in December 19. And up until, well, I had not had any concerns expressed to me at that point about the Post Office running that scheme. Indeed, the settlement deed said this is a scheme that should be run by the Post Office, and it even drew out the stages that should happen for the dispute resolution appeals process. So maybe the question of ownership, as the NAO goes on more recently to describe, should have come up at that point, but it didn't at that point. And indeed, I suppose we regarded it as a relatively small-scale consequence of the December 19 settlement. We were clearly wrong on that.
And who do you consider to be responsible for that underestimation as to how significant a scheme it might have to be?
I suspect there were stages throughout the different players involved. So I think I suspect that the GLO group and Freeths didn't realise quite how many others there were out there, because otherwise they would have probably joined the 555 in recommending that there should be this consequential shortfall scheme. But the Post Office should have had a better sense, or should have analysed more firmly the indicative numbers of a couple of hundred people who might be involved in the scheme. UKGI, as I say, were working closely with the company on HSS for quite a lot of that time, 2020, 2021. And we too in the department probably should have found a better way to analyse it.
I think the initial estimate was 200 applications, is that correct?
I think that's right.
And there were, you say in your statement, 12 times that applied to the Horizon Shortfall Scheme before November 2020, and obviously much more since then as well.
That's right, and probably a lot more to come, as the Post Office is now writing out to a much wider cohort than the 4,000 plus that are already in the scheme.
Who made that original 200 applicant estimate?
I think it came from the Post Office and Herbert Smith, based upon the conversations with Freeths and the GLO group. I don't know for sure whether Freeths gave that number or whether it was just a Post Office estimate. When I had to give some advice to Alex Chisholm about what was happening in the mediation, he asked me to spell out, as accounting officers do, what other sort of consequences would come about as a result of agreeing to the mediated settlement. And one of the issues that I highlighted there was what I was being told about the need to run a Horizon Shortfall Scheme. And we took that number from what we were given by the Post Office at a time of fast-paced mediation, I would say.
Were your department doing any work on trying to estimate those numbers?
No. As I say, at that point, I still had a relatively small team and was taking a lot of advice from UKGI. I have reflected a little bit on this because it's obviously quite a big point of criticism about our failure to understand how big the HSS was, and I think that's, that would probably be fair. In my heart of hearts, I think I probably didn't particularly think it mattered how big the scheme was in relation to settling in December 19, because I did not think it was material to whether the Permanent Secretary should accept what was on the table from the GLO group, and I regarded it as our best estimate at that point to answer the question from the accounting officer, and that then the scheme would run. And whereas with the 555 group you have a defined cohort, there must always be a risk when you run an open scheme that more people apply than you realised. Is that a failing? Well, if people deserve the redress and they apply, no, as long as you can respond to them quickly enough, which is a separate question.
We know that UKGI had a non-executive director on the board for many years prior to that. Did they give you any estimates about the numbers of likely applicants?
Well, that was the UKGI team to which I was referring. So Tom Cooper was the shareholder representative and had been for about a year, I think. And it was either he or his team that provided the figures. And I think it was his team that then wrote the advice to ministers that said, this is what the settlement is, and this is the number that we've been given of the 200 potential claimants to the HSS.
So the numbers came to you from UKGI, but you think that's likely to have originated from the Post Office itself?
Yes, I don't see how UKGI could have made an estimate without information from the company.
We know that Herbert Smith Freehills were involved in that original process in building up the scheme. You've probably heard some criticisms of that. What is your personal view about their involvement?
You mean rather than my view about the scheme that they designed?
Yes.
So I have heard quite a lot of criticism of HSF from the perspective of people saying HSF were guilty and culpable for the way in which the Post Office ran its litigation. I have found that harder to accept because I know that they were brought in to play a role for the Post Office around April time, after the judgment had actually come out. So I think it is important to be clear that when their role started, I think that there has been quite a lot of criticism about their sort of high-end city law firm, slightly assertive approach that sometimes rings true to me from having seen how some of those schemes have rolled out. And I have had quite a bit of personal sympathy for the view that Kevin Hollinrake expressed earlier about how the Post Office needs to change its law firm, supporting it in a number of those schemes, for the reason that we had feedback in Parliament and elsewhere about how Herbert Smith were handling some of the dispute resolution meetings with claimants. I remember Alistair Carmichael in the Westminster Hall debate talked about a meeting that he had heard about where a victim had met with Herbert Smith, and Herbert Smith had not been particularly friendly with them. And I know that the Post Office took steps to put Post Office staff into those meetings because they felt that that would respond. So that's not to say, as Kevin Hollinrake said earlier, there are good people in Herbert Smith who have worked very hard on the schemes, but I think that they are both, from a reputational perspective, not well liked by the postmaster community, and from a costs perspective, they have, I think, extracted quite a lot of money from the Post Office, who haven't managed them as effectively as Sarah Mumby and I would have liked from a costs perspective.
Lorna Grattan's evidence, her written evidence, we'll be hearing her oral evidence tomorrow, is to the effect that the Post Office's external lawyers have taken a legalistic approach, and she's also referred to a cultural clash with the approach of commercial litigators. Do you have a view on that?
I mean, some of that is what I suppose I was hinting at. When we were working with the company on the OC scheme, which we were more involved in from the department than we were in those early days of the HSS, the initial approach that was taken, which was very, I suppose you would say, mediation-based, seemed to be being really slow. And I've apologised to Jo Hamilton for how long it took for her claim to work its way through those early stages. And it seemed to me that it was quite confrontational, and it didn't feel to me that it would deliver the outcomes that ministers wanted. And the steps that the company then took to bring in more of the remediation scheme, which was a drive led more by some of the people that Nick Reed brought in rather than by Herbert Smith. It was, as you probably heard from Mr. Riccaldini, a group of people came in. That to me seemed to be an improvement on the kind of approach that would be more classically the commercial litigation approach that you've mentioned from Lorna Grattan's evidence.
Thank you. I'd like to address your department's approach to the initial historic shortfall scheme. Could we turn to UKGI 3012774? And this is a meeting of the 22nd of October 2020 with Minister Scully. I'd like to start on page 4, please. Actually, sorry, if we have a look at page 1, because you can see there it's a readout of Minister Scully's call with Nick Reed. If we scroll down, we can see you're listed as a government attendee.
Yes.
If we could keep on scrolling down, there are various matters that are raised, not all relating to the Horizon system, not all relating to the litigation. But if we go over, please, to page 4, I'm just going to read to you 3 bullet points from there. Thank you very much. So we'll start on that second bullet point. Minister asked for a quick update on the Criminal Cases Review Commission. Declan said magistrate cases are going to Crown Court of Appeal. Decision is expected shortly. The Post Office will immediately engage with 6 cases if they are overturned and will try to head off malicious prosecution. Declan said the Post Office will look at how well they can mediate those 6 cases as a test case of how to handle the other cases. Tom Cooper said he agreed with the sentiment, but there's a lot to discuss in the approach around managing these cases, which will be discussed at the board meeting later. Tom said that it's not just a board issue as it involves approvals and funding. The Post Office have been given interim payments of up to £10,000 on the schemes, increasing amount of noise in the system, e.g. calls and emails. Tom Cooper said that the Post Office want to unblock de minimis payments on the HSS scheme. Just pausing there, because we'll get to another email that talks about the de minimis payments. Can you briefly explain what the de minimis payments were?
Well, this is quite similar to the conversation that was being had with Kevin Hollinrake earlier around the scrutiny threshold for the GLO. And so the approach that was being taken was to say if the claims were quite small, they should be paid with minimal levels of scrutiny. That would enable the company to have more resource to focus on the more complex claims and ensure that money could go out the door quickly to those people that were bringing the claims. The point, I suppose, that Tom is making is you can't just deal with one part of the elephant. You need to be clear about the overall liability for the scheme and the overall approach, rather than just saying, yes, it's fine, we'll deal with that. You have to, in government approval terms, outline the overall shape when you're trying to get approval for it.
So is it fair to summarise that as the Post Office wanted those small payments to happen quickly, and your department or UKGI or government as a whole wanted to look at the overarching scheme first and establish the entire thing before speeding up those small payments?
Yes, I think that's fair to say, yes.
The other issue is wrongful trading for the directors, as if the Post Office start making payments under the scheme but don't have the funding to complete it, then that could put directors in a tricky situation. We've heard quite a lot about wrongful trading. We heard about it from Simon Ricalden the other day. Is it a real difficulty for the Post Office? Because as you said, that the numbers were always going to hugely outweigh, in fact, the amount of money that the Post Office can make.
So at the beginning, actually, the view was that the Post Office could afford the potential scale of liability in relation to the HSS. So our role as a department was more, as it had been for the December 19 settlement, to approve it from the perspective of the overall principal accounting officer working with Treasury, because it was a novel, contentious and repercussive type payment. But as time went on, and as the cost well exceeded what the Post Office could afford, then it became a broader and harder question for government, as Sarah Munby talked about in some depth yesterday, because we then would need to go through the approval mechanisms, which I recognise can sometimes take a long time within government.
It may be an issue that we return to at the end of your evidence. We've heard quite a lot of evidence throughout this phase of CEOs, chairs coming into the company, being told that they need to make the company financially viable, and then constantly having to go to the Post Office with a begging bowl, to the government with a begging bowl for money. Do you think the setup of the relationship between government and Post Office inevitably creates that kind of a situation that's being discussed here?
It's hard to think of an alternative that would avoid this situation. If you were to create an agency that was a real arm's length body, an executive agency, and make that the Post Office, you would have quite a different setup, and then the liabilities would be ones for the core department. But what you would lose, I think, is that slightly more independent commercial flexibility where you would have the Post Office being run as a big retailer. The wrongful trading risk is one that has been mentioned to us quite a lot over the 5 years during which I've worked with the company. The finance people in my department tend to take the view that it is overplayed by the Post Office leadership as a way to get quite large commitments from the government to underwrite whatever they want to do. And so I think on the government side, it's fair to say, as you heard from Kevin Hollinrake earlier, quite often we have felt that the Post Office has opportunities within how it runs the company to make some savings that would allow them to absorb some of the costs. That said, if you take the long view over a number of years, and this was the start of it, it became very clear that the company could not afford what it needed to do in order to get redress to the people who had been victims of their activity. So this may at an inflection point have been slightly more debatable, but actually it was pretty clear quite quickly that they couldn't afford all of this. And as I said at the beginning, I'm not sure that an alternative governance arrangement would have removed that wrongful trading risk in any sort of clear way. You would have just taken it up to the departmental level where the department would say, we have now got this liability on the core departments because it's an executive agency, and Treasury, you need to fund it because otherwise we will have insufficient funds.
Thank you. It continues, the Minister said, if can get the information on the de minimis case as soon as possible so he can look at that. Carl said that Bayes will work with the Post Office and UKGI to facilitate as quickly as possible, but that control considerations and financial considerations with Bayes Finance and His Majesty's Treasury need to be worked through. As the Post Office are now looking at funds in the region of £100 to £200 million, that is very different to the original advice that went to ministers and the Permanent Secretary previously. Declan said that virtually all 2,000 have gone through the eligibility test. Declan said funding element is vital to progressing to the next stage. Can you assist us with the control considerations and financial considerations?
Of course. Well, as I was mentioning earlier, this question of whether something is novel, contentious or repercussive is quite important when it comes to deciding whether a public corporation like the Post Office can proceed with something that the board would like to do. So there is the accountable officer, in this case it was Nick Reed, and then there's the principal accounting officer, Alex Chisholm, I believe, at that point. And I don't think the Permanent Secretary could just decide to approve this and let those payments happen, because Treasury needs to be consulted because it is a novel, contentious or repercussive proposal. So that's partly what I mean by the control considerations. The financial considerations is about where's the money going to come from. And I think Sarah Munby talked at some length yesterday about how, if I remember correctly, this took about 4 months end to end, and there are steps that we have to go through, both within the department and then with Treasury, to convince them that all of this can be funded. And this was the first of a series of redress schemes where we found ourselves having to go to Treasury to ask for approvals. And I think it's fair to say that the confidence in the Post Office early on was quite low from the Treasury side, and over a period of time it has become easier and better. But I remember one of the business cases, I think it was for this one, we had 29 questions back even prior to the actual approval meeting where we went and had proper scrutiny from Treasury. So there were some sort of forests to pick our way through before we could get the approval.
So, rightly or wrongly, would it be fair to say that at this stage the Post Office wanted things to go faster than in fact the government could implement?
Yes.
Thank you. If we please turn to UKGI 000131196.
And before Mr. Blake takes you to that document, just so that I've got this clear in my head, the settlement is December 2019. And I think I must be right in inferring that the idea of a scheme for people other than the group litigants themselves must have come from the group litigants.
Yes, absolutely. I think...
And so it follows, does it not, the Post Office agreed to that without, in truth, having any idea how many people might be involved.
Yes, I think that's right.
Right? And having done that, the scheme starts and still nobody has any idea how many are going to apply.
Over a period of time, obviously.
Sure.
But I think that's right.
But the scheme starts in May 2020 from memory.
Mm-hmm.
Still nobody knows what's going to happen. There's a slow start and then a rush. And nobody's got the money to pay for it.
That's right.
That's it in a nutshell.
Yes, the original estimate at that May point was 33 million, which could have been afforded by the Post Office. And then when the rush came, it became clear that it couldn't be afforded.
Yeah. Okay. Carry on, Mr. Blake.
Thank you. If we bring up on screen UKGI 3013196. This is your department's Historic Shortfall Scheme Steering Committee, minutes of the 27th of January 2021. You are the chair, or were the chair of that committee. Are you still the chair of that committee?
Well, I am the chair now. I was actually standing in for Mike Kyogan, who's mentioned later on, because he was originally the senior responsible owner for the HSS, but I then actually took on that role. So I became the chair. I was covering this role for this meeting, but shortly thereafter I became the permanent chair, and I've chaired the meeting ever since.
Thank you. If we scroll down and over the page, please, there's a section on de minimis payments. And it says there, TEC, so that's Mr. Cooper, I think, presented the de minimis paper. He noted that the Post Office wanted to make these payments in November, but the Department for Business did not provide its approval due to issues around funding and precedent-setting elements. Both of these aspects have now progressed. I think we've dealt with some of those this morning, but can you just briefly assist us with what those issues of funding and precedent-setting elements were?
I can't remember the very specific details about how we resolved them, but I think the question was what will it take us as a department, as raised with Minister Scully, to say, yes, the Post Office can go ahead with the de minimis payments, because it would be a quick way to get some money to the claimants and close down those claims. The precedent-setting question is what I meant around the novel, contentious and repercussive, i.e. if you agree, as I said earlier, about one part of the elephant, if you agree to this particular intervention, does it mean that you have also taken decisions about the rest of the scheme at the same point? And I think that we and our finance team and Treasury just wanted confidence about what we were signing up to, in effect.
It says for fully quantified claims, the issues were in relation to the interest and legal costs. The Post Office wanted to pay compound interest and contribute to legal costs. Both set precedents. UKGI challenged compound versus simple interest, and the advice from Herbert Smith Freehills is very clear. On legal costs, the Post Office is providing £400 for de minimis claimants towards legal fees and £1,200 for claimants with bigger claims. UKGI has also seen other advice from Herbert Smith. UKGI is recommending that fully quantified de minimis claims be paid as soon as funding is confirmed. The payments will also need to be signed off by the BEI's Permanent Secretary and BEI's ministers. If we scroll down, we can see the approach towards partially quantified claims. If we scroll down, please, over the page. Turning to partially quantified claims, Mr. Cooper noted that the Post Office are taking a more generous approach and gave an example. He noted that officials are less comfortable with this. However, it's unlikely that we will get more information from the Post Office, given that these claims, as per the de minimis principle, are not being investigated. Does this show, again, at this stage, the department is more cautious than the Post Office with respect to payments and quick payments?
Yes, I can't remember whether officials means UKGI or BEIS. It could be either or both. But I think you're right. I think it is. I think this is probably the department scrutinising what the company is proposing and raising some questions about that.
If we could turn to UKGI 3043650. We're now on the 9th of March 2021, another steering committee meeting. If we scroll down to the bottom, please, there's a section on HSS finance docs and issuance of settlement offers. JS, that's, I think, Joshua Scott from UKGI.
Correct.
Introduced the item. On the issuance of settlement offers, he updated that the Post Office have around 100 ready to be issued, but we're waiting on the issuance of the funding commitment letter before proceeding any further. TC, I think that's Mr. Cooper, also noted that the funding commitment letter was among a suite of wider funding documentation that were all interrelated. CC, I think that's yourself, and Mr. Cooper expressed concern about the risk of other outstanding issues, such as the changes to branch definitions causing delay, but noted that it was a decision for the Post Office Management and Board regarding progress on settlement offers should other funding documentation be delayed. So at this stage, the Post Office is ready to go with 100 settlement offers, but they are waiting for a funding commitment letter.
Yes, and the funding commitment letter is a standard piece of documentation that normally the finance director from my department would send to the Post Office before it can make a commitment, especially when we've had to go to Treasury for approval. The point around branch definitions is a separate one.
Yes.
That is more about how the Post Office Board feels comfortable about its overall financial position. And the question here was whether there was an interrelationship between the two, i.e. do we need to have both resolved the funding commitment letter and given the company clarity about what it can count as a post office, where ministers had given more flexibility to the company before it could proceed.
Thank you. The funding commitment letter issue goes back again to the wrongful trading issue, doesn't it? Because without that commitment, there could be a suggestion that the Post Office is acting improperly because it doesn't have the funds.
That's right, exactly.
If we scroll down the page, please, and over to page 3, under any other business, towards the bottom, I'm just going to read some of this for you. It says, CC, I think that's yourself, noted that Nick Reed had written to Minister Scully over the department's role in the delivery of a scheme for criminal cases. So we're now moving on from the HSS scheme to the overturned convictions scheme. You set out your view that the department and UKGI do not have the capacity nor capability and would struggle to build this sufficiently. Furthermore, the Post Office holds the relevant information and there would be difficulties in a third party managing the scheme without direct access to the information. There was also a point that it would be more appropriate for the Post Office to continue to have ownership from a moral perspective over resolving their past issues. NB, that's Nigel Boardman, I think.
Yes,
right?
who was the chair of the Audit and Risk Committee in the department.
He built upon these points and added a concern that accepting Nick Reed's proposal could create a precedent to other partner organisations. TT.
Tom Taylor, the finance director.
Thank you. He also added that direct involvement in schemes would remove the fire break for ministers, which can be important protection. So at this stage, there are a number of different reasons why the department considers that it shouldn't be running that scheme. If I could summarise what I see there, and you can please assist me if I'm wrong, it is for reasons of capacity and capability, for reasons that the Post Office should have ownership from a moral perspective, and also for reasons of a fire break to distance ministers from the scheme.
Well, there's a fourth and a comment I have on the third. The fourth is that the Post Office holds the relevant information, and as we know, access to that information, disclosure, has proven problematic throughout, and so that was an important fourth factor. I think on the fire break, the point that the finance director was making was around potential legal action against the department. So I don't think it was plausible deniability or something like that. Ministers always felt politically accountable for whatever the Post Office did anyway, whether it was done by them or done in-house. But I think the finance director would be more concerned about potentially bringing a legal liability into the core of the department. You say that is the department's view. This was a conversation with a number of representatives at the point when that letter had come in from Nick Reed, and the mood in that meeting was this was the Post Office trying to shift the problem onto the department and get it off their books. I hope you might then move on later to the advice that I gave Sarah Munby and then the submission that we put up to ministers on this point, because my view on this shifted after this meeting.
Perhaps if you could explain that briefly, and then we'll come back to the various reasons.
Okay. So in Sarah Munby's submissions, a written statement, she quotes quite extensively from an email that I wrote to her, where I said that I felt that given how slowly the HSS was moving, the model of the Post Office delivering OC was not right, and that we should consider setting up a new directorate in parallel with my own, with a new director overseeing the OC redress scheme. Sarah replied to that, and I think she touched on that in her evidence yesterday, and said that she would like me to do a proper note, which I then did, and she rightly yesterday said she approved it without changing it, to ministers outlining the pros and cons. And that eventual advice went to Kwasi Kwarteng and was a mixture of pros and cons on a delicate question about whether we should set up a new team or not. From my own perspective, I had previously had some experience of a compensation scheme in the department, and I was also under quite a bit of financial headcount and admin budget pressure within the department. So some of these points around capacity and capability were things that I felt quite strongly. It's a very different environment now, but at that point it was difficult for me to see how I would have been able to get hold of the skills and capacity to do this. That said, between this email, this note, and then my advice to Sarah Munby, I felt that the balance had shifted given how HSS was going towards a different approach, which ultimately Kwasi Kwarteng decided not to pursue.
In terms of the position of the Post Office, we see there, it seems to be at that stage, the Post Office's view that this should be a scheme that was run by government.
Yes, and Nick Reed had articulated that in a letter to Paul Scully, saying, well, the HSS is one thing, to summarise it slightly crudely. It doesn't look like an HSS-style scheme is what is wanted by the OC victims. And actually it would be much better for the post office if it could be dealt with by the government, allowing us to focus on the future of the company.
By that stage, had Nick Reed expressed any concern to you or any concern that you're aware of about post office running the HSS scheme and whether government should instead be running that scheme?
No, I don't remember that. Obviously, Nick and I spoke every fortnight at least, and he and I did discuss difficulties with the scheme, with the HSS scheme, but and this has come up quite a bit in the different evidence hearings. You know, should the post office have said in the compensation hearings what it really thought about this issue? And I think quite a lot of the tone of my conversations with the company were about, this is the situation in which we find ourselves, so let's focus on what we need to do to make it work. And I think that, you know, without trying to provide excuses for the company, I think that was probably the view. We've taken a decision with ministers about how these things should run. We're trying to make them work. So Nick wasn't saying to me, oh, please, can you just take on the HSS? Because it was in mid-flight, and changing things in mid-flight can be disruptive. This was at the point before OC had launched, where he was saying, before we get into this, we need to have a conversation about who should run it.
We spoke earlier looking at the litigation and issues with the competence of the post office, the culture within the post office. You've expressed here issues, a number of issues, but you're being asked by the post office to manage this other scheme. Was this a moment to revisit the question of the historic shortfall scheme and at that point to have made a different decision?
I suppose there would have been moments throughout, before this time and afterwards, when we could have said, stop doing that work, please take it on into the department. But I think the arguments I articulated earlier about changing horses in midstream, this was at a point when people had applied to the HSS, they were there being assessed for eligibility, there was Declan Salt and his team working on them. They pointed away from trying to take it on, and furthermore, we hadn't had complaints that I can recall saying the post office shouldn't be running the HSS. As I said earlier on, the settlement deed said the post office should run the HSS. That is what was happening. I think if you take the long view, concerns about how the post office, whether the post office was appropriate from the postmaster's perspective for running those schemes, have grown over time. And I don't think that was the argument that Nick was particularly making about why the government should take it on. I don't think he was particularly saying the postmasters don't want us to run the OC scheme. I think it was a range of other reasons that he was articulating. But obviously, with the benefit of hindsight, it's probably fair to say that there were points when we could have said the department should have taken it on. One final point, though, is that I wasn't convinced at this point in this meeting that we would necessarily do a better job, given that we didn't have a team of case assessors or the admin budget to actually do it.
Thank you. If we could turn to Bayes 40988. I think this is the email from yourself to Sarah Mumby on the 26th of May 2021. And I can just read those first two substantive paragraphs. If we scroll down, you say, compensation for criminally convicted postmasters. The post office will have now received the awaited merits opinion from their lawyers. We understand it provides an assessment of the strength of potential malicious prosecution claims from those whose convictions were overturned at the Court of Appeal, and concludes that all postmasters are likely to have a strong basis for a claim. This means we're looking towards the upper end of the financial cost band. It might also make things easier because the post office shouldn't be tempted to resist any legal claim from this group of postmasters. Our plan for the short term is to seek approval within Bayes and then HMT for interim payments for these individuals. My team will work with UKGI on the business case for this, and we plan to submit an in-principle submission to you in the next few days. I may need to ask you to prompt Charles Roxburgh. That's his Majesty's Treasury.
So yeah, second permanent secretary at the time.
Thank you. If it looks like we're going to run into Treasury issues on the proposed interim payments, but that should wait until after we've agreed the business case here, we then need to do further work with UKGI and POL on how we administer the rest of the compensation, and Mike and I would welcome your thoughts. It looks increasingly likely to me that we should consider taking on responsibility for the design and delivery of the compensation scheme within Bayes, though that would have large resource implications. So by this time, had your personal opinion shifted as to who should operate that?
Yes, this was the email that I was referring to that described my shift in position. And that partly came about through conversations with Mike Keoghan, to be fair, who was my then line manager as Director General. He had had some experience from afar around the coal health claims that the department had dealt with before for other compensation schemes. And he mounted the argument that actually the civil service have quite a lot of people who can do operational delivery who could have been brought in to help run this sort of scheme.
And to the best of your understanding, why was it ultimately rejected by Kwasi Kwarteng?
So there were a couple of steps after this. First of all, we talked to Paul Scully and to Lord Callanan, who was then representing the department in the House of Lords on post office matters, and also to special advisors on the back of some advice, a formal submission that went to ministers, and that's the one to which I referred earlier, that argued about the pros and the cons. Views were split across those different people. I think Paul Scully favoured taking it on in-house. Lord Callanan expressed a view that it would be better to leave it with the post office. We purposefully presented it as a set of options rather than a recommendation to ministers because we felt they needed to weigh it up and reach a political judgment about it. I attended a meeting that happened with Kwasi Kwarteng. I believe Sarah Munby was there as well, and Paul Scully and Lord Callanan and special advisors and Mike Keoghan and others. And we talked it through with the then Secretary of State. And he weighed it up and discussed it with people and ultimately concluded that it would be better to rely on oversight of the scheme from the department, ensure that there was sufficient governance over the scheme, but ask the company to run it themselves.
Thank you. So that might be an appropriate moment to take our mid-afternoon break. I think 3 o'clock.
3 o'clock.
Mr. Creswell, I'm going to move on to a number of specific issues that have been highlighted in relation to the HSS scheme. The first is access to lawyers. One issue that we've heard from, especially from Mr. Ricaldin, is the inability for lawyers to give early advice in relation to the HSS, and also to commission early reports such as forensic accountancy reports and matters such as that, because funding isn't available at that pre-offer stage. Do you see that as an issue with the Horizon Shortfall Scheme?
So I think it's a fact of the design. That's correct. Legal advice is not available up front. It is available at a later stage. The origin of that, and this is something that was discussed during the compensation hearings and Sir Wynn's interim report, I believe, was that the desire right at its inception was to try to avoid a very lawyer-heavy scheme. So my understanding is that the discussions around the settlement deed set out a requirement that the Post Office should run a scheme that was not full of lawyers. And I think that is indeed how the HSS has run. I think that the advisory board, with whom I work closely, have expressed some concerns about how far HSS has gone in delivering fairness. I think a lot of the claimant lawyers, many of whom met the advisory board and myself last week, would say more fairness would have been achieved if those claimants had had legal representation. So I do recognise those criticisms. I think it's a very different model to the other schemes that we are running. And I know Sir Wynn, I believe, commented that he thought that the HSS, in theory, was capable of delivering fair outcomes. I think some of the criticisms of the scheme have been about the late provision of the consequential loss guidance, the overcomplicated nature of the form, how hard it is for vulnerable victims to fill in the form, and so on. Whether lawyers are the answer to that or not, I think, is a question on which others probably would be better placed to reach a view. I would say that on those schemes where we have a lot of legal representation involved, the number of claims that come forward is much lower. So if you look at the OC scheme, it has taken a very long time to get to the point that we are now, where over half of the claims have been submitted. I'm not saying that is purely the fault of the lawyers by any means, but it is striking that the HSS scheme was designed in a way to try to encourage early submission of claims to the scheme, and then, having met them, the independent panel would say that they've worked hard to draw out the issues for which the claimant should get extra compensation beyond what they have stated in the form.
So when you say come forward in terms of the overturned conviction scheme, for example, you mean you have applicants who fully intend to apply, but the building of the case at that initial stage with a lawyer takes time that isn't in the HSS scheme?
Yes, yes.
We've seen a lot of references to trying to keep the HSS scheme and the GLO scheme consistent with each other. That appears to be an inconsistency between the two. Why is there that specific inconsistency in respect of the Horizon Shortfall scheme?
Yes, yeah, very good question. I mean, we worked with the advisory board to try to ensure alignment around the principles for the GLO scheme cohort, because both HSS and GLO have non-convicted claimants, and we need to ensure consistency of principle across the piece. But what we also did was worked with Freeths, whom we paid in effect to help us design the scheme, and we worked with the JFSA to design the GLO scheme. And one of the points we heard through those conversations was about a lesson to be learned from the HSS, which had been running for a while at that point. And the requests were to ensure that legal advice was available up front, because it was felt that that would better help the GLO claimants to formulate their advice. And obviously a lot of the people in the, it's not quite 555, it's the 492 people within the scope of the GLO scheme, had an existing relationship with Freeths or with another legal firm who could help them formulate those claims.
Thank you. The topic of delegated authority, Mr. Ricaldin also gave evidence in relation to the levels at which that is set. In 60% of cases, he said he had to seek further authority. And in his view, the level at which authority is required is set at too low a level. Do you have a view on that?
I think over time we have seen more delegation towards the post office across a range of different aspects of the schemes. So, for example, on OC, I hardly ever see a non-pecuniary claim and offer now. It's dealt with by the post office within a very clear set of principles that have been signed off. We tend to see more pecuniary claims because those principles are a bit fresher and tend to be a bit more novel in their nature. I think...
Sticking, though, in respect of the Horizon Shortfall Scheme in particular.
Yes, yeah. I think it's probably true that the collective view in government has been to give Simon and his team a certain amount of discretion, but not completely unfettered.
And do you consider that changing that level of authority might speed up the Horizon Shortfall Scheme?
I'm not sure that that is really critical. I've spoken to Dr. Hudgell quite a bit about how the HSS scheme is working, and over a period of time I've tried to develop a relationship with some of the claimants' lawyers to try to find out what is going on from their perspective, so I'm not just dependent upon information from Mr. Ricaudin. The number of cases in the dispute resolution process is quite small, and so when Simon talks about more delegation, he's talking about his ability to mediate a settlement in a handful of cases. So I can't remember the exact number, but it's something like 5 or 6 claims have been settled through mediation this year. What has made a much more material difference in terms of full redress has been the 75k intervention.
Thank you. And that's the next topic, the £75,000 offers and top-ups. Do you understand legal advice to be available to those given the £75,000 offer or top-up?
No, it's not.
No.
No, it's not at that stage.
And do you consider that that is helpful or unhelpful? I think this is a matter on which there was consensus in the House of Commons when my ministers announced some of the interventions. So both my current set of ministers and my previous minister, Kevin Hollinrake, were of the view that what was needed was an intervention that would get us to full and final settlement for those people that chose to accept it as quickly as possible. And I think they took the view that having every claimant go and get legal advice would mean that aim would not be achieved for a very long period of time. So back to my point around how many claims have come through for the OC, I think we're talking about 61 out of the 111 plus probably PNC cases have come forward. On the HSS scheme, we're talking about over 4,000 cases at the moment. The wider population who could access the HSS is about 24,000 people. Now, that doesn't mean that they will all apply, but I think if you look at it from the perspective of capacity in the market, I think it would be difficult to see how the legal community could support that volume of claim. One of the documents that I took Mr. Ricaudin to, I can bring it up on the screen if you want, but I don't think it's necessary, is a meeting at which he raised a concern, he notified you that, and others, that he said claimant lawyers may ask, how can I advise my client, this is in respect of the £600,000 payment, is good enough given no disclosure. I don't know if you saw that document. I think it's forwarded to you, actually. You were present as well. The concern there being, without disclosure at that stage, how can somebody know if the figure is sufficient? That presumably also applies to the 75,000. So you don't have a lawyer, you don't have disclosure at that stage. Do you think that important rights of individuals to know the underlying information are being taken away by that process?
But I think that the 75k, if you look at it through the lens of the HSS, is quite a large sum of money, though it might not sound it. But compared to the average offer that comes from the independent panel, that is quite a big uplift for many people. When I've discussed it with some claimants' lawyers, more privately, they have said that they feel that for many people who have suffered a shortfall and the distress and inconvenience that comes with that, 75k is an overpayment based upon what they would be sort of expected to receive through a full sort of legal assessment. The more complex claims, where 75k might not be sufficient based upon HSS and other precedent, is where there are other consequential losses or a termination or other sort of factors. And those are the claims that I think are more likely to lose out, I suppose, in accepting the 75k. I mean, of course, the lawyers, with respect to the people in the room, are always keen to have more clients. And so this is partly the conversation I've had with claimants' lawyers, who have said every person who applies for the £75,000 should get access to paid legal advice. But in the inherent design of the HSS, as I said earlier, was to try to avoid that.
I don't know if you heard the discussion with Mr. Hollinrake about the position that people are put in respect of the 600,000 or equally for the 75,000, and the risk that is involved in that decision if they can't later down the line say, actually, I've changed my mind. What's your view on that?
I did hear that, and I heard Sir Wyn's comments on it as well. I think I would say that Kevin Hollinrake touched on the accounting officer considerations in relation to the 600,000 or indeed the 75,000. We didn't need a direction in the end, although the Secretary of State or Minister Hollinrake, as was, would have sought to give one. And the reason for that was we got ourselves comfortable with the fact that this was an efficient way to deliver the outcome that ministers wanted to see. So that is what VFM means for me. It's about the most efficient way to deliver the outcome set by ministers. Now, prior to late 2023, there was probably more emphasis on full and fair and a bit less on prompt. And then towards the end of the year, the political pressure on us became higher to deliver things more promptly, even if that meant that you were foregoing some fairness in terms of consistency between different claimants. This point being that some people would gain more than others if they all level up to 75 or to 600,000. But in accounting officer terms, it was justifiable to achieve that sort of intervention without a direction, because it was about delivering ministers' aims.
And is part of that then intentionally carrying a degree of risk to incentivise the acceptance of those offers?
Yes, and I'm afraid that is the conversation we had with ministers, which was why I'm sort of agree a bit more with what Beth White had written in that email, which has been discussed, I know, because I think from the politicians' perspective, they were publishing regularly data showing how much money had been paid out to lots of claimants, and every member of the OC 111 has had at least £200,000 in terms of interim payments. But when you, as a politician, give a big number, people quite understandably come back and say, yes, but these people haven't had their full and final redress. You've given them loads of interim payments, but it's just a big number that doesn't mean anything to the poor people who haven't got to the end of the process. And obviously, that's very unfortunate. So the political desire was actually to try to target more full and final settlements, because that was bringing closure to those individuals and giving more demonstrable progress. It wasn't, from my point of view, get as much money out of the door as quickly as you can by giving people even higher interim payments. And actually, I think Mr. Ricaudin was incorrect in a couple of points in his evidence, but one of them was around this 600,000 being possible to be offered as an interim payment. It was expressly not. The government policy was not 600,000 as an interim payment to every member of the OC. It's a fixed sum offer.
You said that Mr. Ricaudin was wrong in a number of places. Just while we're on that topic, if there's anything else that you think should be drawn to the Chair's attention?
There are a couple of issues. One of which is he implied that it was only recently that the department became comfortable with approving interim payments of a large size, which is why he was saying we should have done the £600,000. That is not true that we have only recently got comfortable with approving large interim payments. We have approved six-figure interim payment sums from 2022 and 2023 onwards. So I think that was incorrect. He also talked about the HSS appeals announcement being made in March. It was not. It was made in September, because I think that's important, because it makes it sound as if we've been sitting on our hands since March. but we are currently consulting, and I can say more about what we're doing there if you would find that useful. And then finally, his comments about Emily Snow, who's an excellent member of my team, were completely incorrect about when we consulted the Post Office. We consulted Simon McAlden's team in June 2023. We got the data from the Post Office in order to build the business case for the 600,000 intervention. Emily then wrote on the 5th of September to the team in the Post Office saying, would you please consider the operational and delivery implications? She outlined our plan for HSF, Herbert Smith, to write to law firms on the day when we announced it. Eleanor Brooks, also in my team, spoke on the 12th of September to Simon. Our comms team talked to the Post Office comms team. I raised it with Simon myself. He wrote to us thanking us for sharing the analysis for the 600K. And then we discussed it at the quarterly shareholder meeting. I'm sorry that's a little bit at length, but I felt that the account that was given the other day was disingenuous because we had been involving the Post Office, including up to the level of Nick Reed, for a while. I think the issue, though, which I think is worth being aware of, is that Simon and team did not agree with the £600,000 policy. They felt that it was cutting across and undermining the principles-based system that they had been working on developing with the claimant lawyers for a very long period of time. And we were caught, from my point of view, between the Minister's desire to have a fixed sum offer that would enable swifter full and final settlement, even if it meant overpaying at the individual level, and the Post Office's desire to stick with a claim that was principle-based that would take a lot longer.
Before we go any further, when I read the transcript of today, in respect of the last 5 minutes, I may get the impression that you have told me that there is a shift in ministerial objective from the 3 words, full, fair and prompt, to at least an emphasis on prompt, right? If so, I've not heard any minister or other politician articulate that publicly. And I don't want to be unfair either to you or them. But if it is the case that one of the driving forces behind the fixed offer is to elevate prompt above what is full and fair, I'd like to know it in plain language, please.
And so responding to that, that is precisely what I am saying. I was given the steer by Secretary of State Badenoch and others that we needed, and some of this evidence is included in my bundle, to prioritise speed, even if it meant overpayment.
Well, and underpayment. Because the way the fixed offer operates, once you don't accept it, it's lost forever, isn't it? So there's an overpayment possibility, certainly, but there's also an underpayment possibility.
There is, although the 600K, I would say, is supported by legal advice.
No, I'm not saying that anybody's going to do it deliberately. I'm talking about the effect of it.
Yes, yeah.
I can put myself in a position of a claimant who may claim £1 million, who's prepared to take the risk on not accepting 600. It's much more difficult if your claim is 700 or 750, isn't it?
It is.
Yeah.
May I also add to my comments based upon your earlier question?
Yeah.
I think for me, in looking at your pros and cons that you mentioned earlier, it's worth thinking about the counterfactual of what would have happened if we had not introduced the fixed sums.
I agree. I understand that there are a multiplicity of pros and cons. I understand that, which is why I was trying to tease them out of the Minister.
In terms of the counterfactual, is that principally one of length of time awaiting payment?
Yes, I think I would have been sitting here today with a lot lower number on both the OC and the HSS schemes for completion. My experience on the HCRS, which is the Horizon Convictions Redress Scheme that we set up on the back of the legislation that we designed to overturn so many convictions, has been quite a high rate of people accepting the 600,000. So obviously I'm a civil servant who advises ministers and they ultimately decide, and what we have designed in this space has been to meet what ministers have asked us to do, which is to try to ensure people can get to the end of the process as quickly as possible. I think we probably fall short on some of that, as I've been discussing with Joe Hamilton earlier today. There are still parts of what we're doing that aren't going quickly enough.
Moving on to the topic of employees and assistants, you'll recall that's something that was addressed by Mr. Ricaldin. They're not eligible under the Horizon Shortfall Scheme because they don't have a contract with the post office. Are you aware of discussions to expand the eligibility criteria?
I am aware of exactly that question, and we have been discussing it with Simon's team, and we are preparing advice for our Minister, Gareth Thomas, but we have not yet submitted it to him, but it is a live question. My new ministerial team has been quite focused on gaps between existing schemes, and so in our early time working together, they have been asking us questions about people who might fall between the cracks.
And where do you see those principal gaps?
I mean, I think that is quite a good example. We have also been asked questions around caution cases and prosecuted but not convicted claimants. There is also a question about family members, which the previous government was firmly set against including. Certainly Kevin Hollinrake was clear on that in the House of Commons. So we, and I suppose I should also say capture, where I've worked closely with a number of the postmasters affected. I know that's outside the terms of reference of this inquiry, but we've also been trying to look at the harms that have fallen, it appears, on a large group of people there.
And what is the direction of travel as far as you see it in respect to those cases? All of those, so the various gaps that you've identified?
Well, I think our starting point as policy officials is to respond to the question of, are there gaps? What are the gaps? And then we tend to say, well, what are the options? And what do ministers want to do? And that is a cross-government conversation that needs to happen. So I'm not at this point able to say where I think it will end up. But I think it is quite important, particularly to Gareth Thomas, my new minister, to make sure we are clear about who falls into which scheme. This is also a point that the NAO brings out in its report earlier this year, where they say you need to be really clear about the eligibility of your compensation schemes, the boundaries. And sometimes you draw a boundary that leaves some people outside, and sometimes you need to expand the boundaries to bring people inside. And those are judgments for politicians to make.
In terms of process, I'm just taking an example, an extension to family members or an extension to managers and employees. There would either have to be yet another scheme or it was HSS, because they couldn't sensibly fit in to overturn convictions or exoneration convictions, and they weren't part of the GLO.
I think you are probably right. We could decide, I suppose, to say a postmaster who is in any of the schemes could include family member losses within their claim.
Sort of, what's the correct word or phrase? They could, I can't think of it, but they could bring, the postmaster could bring a claim on behalf of a range of people.
Yes, and some of the GLO applicants have indeed included family losses within their claim, but because of the ways in which the rules were drawn based upon an agreement from ministers, those aspects of the claim are not compensatable, if that's a word.
Yeah, the slang I was thinking of is that you could piggyback certain people onto existing claims.
That's right, and obviously family members would be quite a big expansion.
Sure, yeah.
Do you have sums in mind that you envisage such expansion would involve?
No.
The appeals mechanism, it's something you've already touched on. It's a route, you've explained at paragraph 33 and paragraph 60 of your statement, a route to appeal that's being established. I'd just like to ask you about a number of documents where the matter's been discussed previously. It's Bayes 301092. This is a discussion of the 5th of October 2023, the monthly monitoring meeting. If we scroll over the page, please, to page 2, at number 4, we can see there you expressing some concerns with the potential for an appeals mechanism. It says, the group discussed the advisory board's recommendation to introduce an independent appeals process on the Horizon shortfall scheme. Carl noted that there was a risk that, as envisaged, the appeals process would effectively be a rerunning of the HSS and would be very challenging on value for money grounds. Am I right to say that at that point in time you were concerned about the potential cost of an appeals mechanism?
It's not, well, I suppose cost is a dimension, but in this case, it's the efficiency dimensions of value for money that were on my mind, i.e. Quite a large amount of money had been spent at that point on running the HSS. The advisory board earlier than this date, I think June 23, had first suggested that it might be needed. And at that point, I felt that what was being proposed was basically rerunning the whole thing again for claimants who had gone to the independent appeal and on average, I think at that point, had received about £39,000 each. So I was a bit concerned about that. But we worked on this with the advisory board over a number of months, and the Post Office gave us some ideas as well. At that point, I think I probably hadn't realised quite how many criticisms there were of the way in which the Post Office had run the HSS. And it became clear to me eventually that the criticisms were so large that the advisory board were right, that we wouldn't get closure on the HSS unless we gave individuals the opportunity to bring an appeal with legal support.
If we could please turn to Bayes 301098. There's then another monthly monitoring meeting on the 1st of February 2024, so quite a bit of time has passed by this meeting. If we could please turn to page 3. We see there again the appeals mechanism is discussed, and it says CEO, that's Catherine Connolly, explained that there have been 70 requests to reopen HSS cases. These will be assessed. However, it was noted that there's limited availability of the panel. The monthly monitoring meeting were told that the department has started to receive correspondence regarding potential appeals too. The department's position is to explain that cases are settled. This aligns with what the Post Office are informing potential appellants. The Post Office stated that the department need to be aware that not everyone had full guidelines, including legal, when originally claiming. There are currently no timescales with regard to appeals, and you advised that the department were minded to see how the £75,000 initiative washed through, how many cases this resolved before further consideration of the appeals process. SR, I think that's Mr. Ricaldin,
yes,
responded by reminding you that this went directly against the Post Office's and the AB's recommendation. What's the AB?
That's the advisory board.
Advisory board's recommendation, currently with the Minister, who had mentioned his consideration in the House of Commons. It also did not consider that an appeals process would address a number of other issues which had been and will be raised at the inquiry. You recognised his points and pointed out additional concern about the potential costs of establishing such an appeals process. So we spoke about value for money before, but actually here it's directly on the issue of costs.
Yes, that's right. I mean, we had advised Minister Hollinrake in December that it would be sensible to look at running an appeals mechanism. We ended up in this early period prioritising the 75k, and this is obviously January of this year when there were lots of other interventions happening, such as the GLO fixed sum. I don't know that I would agree that it was that not introducing it was running counter to the recommendation. Certainly, Lord Beamish, Kevan Jones, and others continued to press for us to do this. The Minister had not ruled it out. He did say that he would do it. My concern about costs was partly influenced by our conversations with the Treasury at official level about this proposal, because from their point of view, we would be effectively double dipping, coming back to Treasury, asking for another version of the scheme that had been quite expensive up until that point. And indeed, I think Minister Hollinrake found it quite challenging to get the then CST comfortable with the idea of launching an appeals mechanism. He wrote in March 24 to the CST and continued to chase in the run-up to the election, but we weren't able to persuade Treasury at that point to agree, and it then went on pause And we picked it up again with new ministers after the election, and they quite quickly agreed that we should press ahead with this intervention.
In respect of the criteria to be applied, that can come down, please. Do you know what the criteria will be?
So we have been started consulting various people on this. I wrote to Callum, who I know is in the room from the NFSP, and also to Sir Alan Bates last week. And we attended a meeting with the advisory board where we aired with them various proposals. Some of the aspects that we covered included the fact that the bar should be quite low, that we would like to model it, this is our proposal, on the HCRS scheme, i.e. people will have access to legal advice based upon a legal tariff, that then we in the department will get some external legal support, but we'll recruit a team of case assessors to assess those claims for appeal, that those case assessors would not see the panel's decision on the case, but that they would have access to all of the documentation that was put together through RFIs, requests for information and other such interventions. We discussed with the advisory board whether those cases that have been through the HSS dispute resolution procedure, that is the appeal mechanism set out through the original December 19 settlement deed, whether they should also be eligible to apply. Our emerging conclusion is that closed DRP cases should not be in scope, because those individuals had access to legal advice and had reached mediated settlements and other such steps, but that anyone whose case is still being considered by DRP could have the option to transfer into the HSS appeals mechanism, that we would use the existing HSS principles, and that we would again have access to an independent panel, but we would not put it up front. I think one of our views is that having the independent panel up front in the HSS appeals process, i.e. pre-offer, has been one of the contributory factors to the slow progress of that scheme. And that's not any criticism of the panel, but it's a recognition of the capacity constraint that is caused by having the panel review every offer. And we would then again have a tier of an independent reviewer, a la Sir Ross Cranston, no, probably not him, on hand if anyone is unhappy with the independent panel's view.
Am I right to understand, therefore, that there won't be a strict criteria for eligibility? I mean, to give an example, the GLO test for the independent reviewer is whether there's been a manifest error, procedural irregularity, or substantive error of principle. Those kinds of narrow criteria, legalistic criteria, will those kinds of things apply, or is it just an appeal effectively as of right to this panel?
So I was interpreting what you said to be about the eligibility for someone to bring an appeal to the department scheme.
Yes.
Our emerging view is that the bar for that should be very low, so the eligibility should be wide. Your point around the independent review is a slightly separate one, because it's not about eligibility for the scheme, it's about the grounds on which you can appeal the independent panel's view on your claim. And this is what is happening in the GLO, where Sir Ross Cranston is that final point of arbitration.
So that's the second layer, but in fact, in terms of the first layer, having somebody in the department review your claim afresh, there won't be any strict criteria that's applied.
Well, we will have to explain who can apply, but our intention is to make that quite broad and open rather than limited, as we found was a criticism for the HSS earlier in its tenure. I would say I see it as 3 stages probably. So we would have a case assessor in the department with external legal support looking at the claim. If someone is unhappy, as per the GLO, they can go to an independent panel, question undetermined whether to have 2 bites of the cherry with the independent panel, and then ultimately an independent reviewer. That might sound convoluted and bureaucratic, but actually those are protections in place for the claimant to ensure that they have an opportunity to challenge an offer.
And we've heard in terms of the fixed sum offer, so the £75,000, that in accepting that you're giving away certain rights, and one of those would potentially include the right to appeal. Is that correct?
That is certainly the current policy.
And can you see a difficulty with that policy in circumstances where the actual arrangements for that appeal mechanism aren't even published?
I can see your point, and it is something that we discussed with the advisory board and are continuing to discuss with with people as we go through the consultation. As I say, what we're trying to do is learn the lesson of, before you launch the scheme, talk to people about any concerns about the scheme.
Is it a possibility that those who have signed away their rights to appeal may, in fact, in due course, receive a right to appeal?
Would it be a problem if we were to allow them into the scheme?
Is there a consideration being given to those who have signed up for the £75,000, waived their right to an appeal, being actually, in fact, allowed in that appeal mechanism because they weren't aware of the circumstances on which you could possibly appeal?
I think we need to reach a view with ministers about what they would like to do. As I say, the proposition that we tested with the advisory board last week was based upon the existing policy, which has been to say, here is a £75,000 offer that you could accept, and that would be final resolution of your claim, or you could continue through the existing dispute resolution procedure or the new appeal mechanism that the department is going to introduce in the first part of next year.
Finally, in terms of the Horizon Shortfall Scheme, end date. Do you have in mind a date on which all that work will be completed?
Yes. So again, on the back of the compensation hearings and some of Sir Wyn's comments, we consulted the advisory board. I think this was one of the recommendations in the interim report that an end date was set. The advisory board's view was that it was too early to determine what that date would be, given that the inquiry was continuing, and the Post Office tends to find that whenever there is publicity about activities, whether it's the ITV documentary and drama or the inquiry hearings, that more people come forward with claims from within that wider cohort. Ministers in the new administration have also encouraged the Post Office to write out to a large number of claimants who haven't yet come forward, as I said, beyond the 4,500 odd that are in the scheme. And so currently ministers have not yet set a date, although I have discussed with the Secretary of State and Minister Thomas the desirability of drawing to a close at some point that window for HSS claimants to apply.
When do you anticipate that will be?
When do I anticipate the end date will be, or when
Yes.
do I anticipate?
On the knowledge you presently have, assuming that the ITV drama was the peak in terms of publicity, when do you anticipate the scheme will end?
Well, I'm not sure whether it is the peak of publicity. We have waves of publicity, of course. I think it's a judgment for ministers. I think...
As somebody with experience of the scheme for a number of years now,
Yeah.
when do you personally think it will end?
Well, I think the question for ministers to decide is between the summer or September next year. I think the judgment is partly how much time do we need to allow people to give them fair access to redress.
And just so there's no public confusion about what we mean by closing the scheme, when I recommended that the scheme could be closed, I meant that it would no longer be possible to apply for compensation, not that everybody had been paid.
And that is what I'm talking about as well.
So we are talking about a date after which nobody would be eligible to apply for compensation.
Exactly.
Right, fine.
Thank you. Moving now to the overturned convictions redress. I'd like to ask you a number of topics that, again, have arisen throughout other people's evidence. The first is delegation levels again. Can you assist us briefly with how the delegation levels apply under that process in respect of the Post Office needing to ask permission to settle claims?
Of course. So the OC has been on a journey from those early cases that were mediated settlements to then the very helpful Lord Dyson E&E principles for non-pecuniary. Once those were up and running, we then gave delegation to the Post Office to work within those principles. And as I say, we only need to see a non-pecuniary offer if it brings in a new head of loss, for example, that would be precedent setting. The pecuniary principles, again, took a very long time to get agreed, but since those have been agreed, they have been applied to more cases. And although we do still see pecuniary offers come to the department, we have given more freedom to the Post Office to make those offers.
Can I just touch on one clarification in respect of your statement? Paragraph 29 of your second statement, you've said that there was agreement of the pecuniary principles between the Post Office and the claimant's legal representatives. It's the inquiry's understanding that there was consultation, but there wasn't formal agreement. Is that something that you understand, or do you have a different view?
I suppose your understanding must be based upon what the claimant's lawyers have said to you. I remember that consultation did happen between the Post Office and various claimant lawyers, and feedback was given and the principles were amended in light of that. I know Dr. Hudgell did say to me that there may be elements of the principles that they would choose to challenge on a case-by-case basis. So perhaps your description is more accurate than what I've said in my statement on that point. However, I do think our experience has been that getting those principles in place is immensely helpful. Even if you go more slowly at first, you can then go more quickly afterwards because the areas for dispute narrow.
Thank you. My other topic under that heading was the £600,000 government offer, but I think you've addressed that in addressing Mr. Ricaldin's objections when it was first announced, and you've explained your position on that.
Yes, I think that's right. I would say that the 450,000 intervention that Minister Hollinrake, Kevin Hollinrake, touched on earlier is also quite helpful from Sir Gary Hickenbottom's recommendations, and he has played a very active role in case management, as he described at the Select Committee yesterday, which I think has really been welcomed by the claimant lawyers. At the meeting last week, when we met the advisory board and the lawyers, there was quite a bit of positive feedback about how the OC scheme was running now, and in particular the role that Sir Gary Hickenbottom is playing in helping bang heads together and so on.
If we could move on to the group litigation, the GLO scheme, could we start on Bays 40722, please? I'll take this quite quickly because this was an email exchange that we saw with Mr. Hollinrake this morning, and it relates to the Chief Secretary of the Treasury's approval of the various thresholds and the Chancellor appearing to resist the upfront offer. What is your view on how receptive the Treasury were to the proposals you were making in this regard? It's page 3, we can have a look at those passages that Mr. Beer took Mr. Hollinrake to earlier today. Thank you.
Well, we got to the right place in the end, which was that ministers were able to announce the intervention that the Secretary of State and Kevin Hollinrake wanted, but it took a lot longer than I think it probably should have done. I know that Kevin Hollinrake challenged what I'd said here about the strong views of the Chancellor. That information was based upon what Treasury officials had told me, i.e. the Chief Secretary was sympathetic to the case from a political perspective, but the Chancellor was taking a bit of a broader precedent view, which, to be fair to Treasury officials, is part of their job to say what is the repercussion of this decision on other schemes. And there was quite a bit of resistance, as you saw through that letter that was sent back, which in summary said something like, good idea, but go away and come back with a different number. And after January of this year, it then became possible to get political agreement on that intervention, which I think was the right outcome.
Thank you. So the original thinking was 100,000, then it went and was agreed at 75,000.
Correct.
Thank you. That can come down. Thank you. The latest figures in terms of the GLO is that there are 306 claims received, 221 claims paid. Is that correct?
Yes, and there are interim numbers as well around how many offers have been made and so on.
Are those figures slightly deceptive in terms of progress because the most complex ones have yet to be settled and may take some time yet?
So it is definitely the case that the more complex claims are either ones that we've just started on or are to come. So I'm not expecting many more 75Ks between now and you still get the occasional one, but they mainly settled early on. Of the 228 offers that have been accepted, 151 accepted the 75K. So that gives you an indication of the fact that we have dealt with some offers above that level, but it's sort of broadly, I think 2/3, 1/3, if my maths is correct, 2/3 75K, 1/3, I suppose you might say complex, above 75K. I don't have any reason to believe, based upon discussions with my team and my analysts, that the cases we've seen above 75K are any more or less complex than the other claims that are coming. I don't think Freeths or other legal representatives have held back the more complex claims particularly. I think they've been processing them as soon as those forensic accountant reports and the medical reports come through. This is one of the points of contention around the scheme, that we are awaiting 186 claims, and the conversation we had at the advisory board last week was about are we delivering full and fair redress? The answer was, from everyone there, generally we are achieving fair and full outcomes. And that wording was included in the minutes that we published earlier this week of the advisory board conversation. The problem is the speed. Yes. And the select committee discussed some examples yesterday that I thought were requiring of more work on our part around the way in which Adelshaw Goddard, who act for us on this scheme, ask for more detail from the claimant side. I mean, the claimant solicitors raised a few issues with us last week. One of them was around Adelshaw Goddard's approach to asking lots of questions. The other was around how long it has taken to get forensic accountancy reports to the quality needed, and there has been quite a long lag there. The other issue that was raised, which I think is quite important, is around the sort of mental health challenges of some of the claimants who are needing to participate in this scheme, whether that's that it's quite intimidating having to fill in the forms, which is something that Joe and I have discussed, or whether people are holding out for the inquiry to complete, which is something that Mr. Maloney has mentioned in the compensation hearings before, and advisory board mentioned as well. Chris Hodges, the chair of the advisory board, said that he felt it was important to say the schemes are there, the money is there, there's 1.8 billion there. So, anyone listening should, feel ready to come forward, was his sort of view. But I can understand that from what the claimant lawyers said, some of the claimants want more time and don't want to be pressed by a deadline for the GLO scheme for when they need to complete their claim.
And one of the issues that has been raised by Sir Alan Bates, for example, is setting a deadline for the GLO to be resolved.
Yes.
What's your view on that?
I mean, Sir Alan has been really helpful for us over a number of years and was involved in the design of the scheme for us, but I know he's unhappy with how aspects of it are running at the moment. I think the view from my ministers, and I think the Prime Minister said this in a letter to Sir Alan earlier this week, that if claims come to us by Christmas, then we should be able to get offers out in the early part of next year. So it is 40 working days is our target for getting out those initial offers in 90% of the cases. We have met that for a number of months, and I would expect that we would be able to honour that commitment for those claims that come to us by the end of the calendar year, which means that we should be able to get offers out to those GLO claimants by the end of March in those situations. Now, that doesn't mean that those claimants should feel forced to accept those offers, and I think however good a job we in Adelshaw Goddard do to give generous and right offers, there will still be some claimants who wish to challenge those offers, which is why I think government ministers have been reluctant to say no one, everyone will get their money and no one can claim any later than the end of March. It's a bit like the point that we've discussed in the inquiry before about the August deadline was an arbitrary one that would have forced some people either to apply earlier than they were ready or they would end up missing the boat. So I think I definitely agree with the sentiment of you should get on with it and get the claims out, get the offers out quickly. But I think the mechanism of saying claimants must apply and you must give them an offer by the end of March might actually end up with vulnerable claimants either being forced to apply before they were ready, if you see what I mean.
Thank you very much. In light of the time, because we have to get to questions from core participants, I'm going to address the next topic quite quickly. That's the Horizon Compensation Review Scheme.
Sorry, Mr. Blake, just so I'm clear, the statistics about the number of people who've made claims in the GLO to the 30th of August 2024 is paragraph 41 of your second statement. It may need a little bit of updating, but that's by the by for the moment. What it shows is that as of the 30th of August 2024, there were 492 eligible applicants, but only 264 completed claims received.
At that point, yes.
At that point,
Yes.
and obviously there'll be a bit of updating.
Yep.
So there are still a very substantial number of people who have not yet made a claim.
Yes, and to be precise about the number as it sits now, 492 is still the claimant cohort.
Yeah, yeah.
306 full claims have been received.
So it's 306 now.
And
Okay.
that leaves 186
Yeah,
that we have not
okay.
received. Now, Freeths, as an example, tell me that they think they will be able to get their claims in by Christmas, and they own quite a big proportion of
Right.
that remaining 186, and many of those claims are, I think, complete in part, at least.
Fine, thanks. Sorry, Mr. Blue.
So the Post Office Horizon System Offences Act 2024, under Section 4, the Secretary of State has a duty to take all reasonable steps to identify those whose convictions have been quashed. Briefly, can you assist us with how you are establishing those individuals?
Yes, so this is a responsibility that's being discharged by the Ministry of Justice. We have two routes in. We have, when the scheme was launched in July, we opened a portal on gov.uk where anyone can self-assess and declare that they think that they fall within the scope of the Act and therefore should be able to achieve redress. And part of the reason for that is because of the passage of time and some concern that it might be difficult for us to track down every last one of the cohort. We have also had data from the Post Office and from the CPS, which has been shared with the Ministry of Justice. That cohort is 949 people in total for England and Wales, which is the jurisdiction that the Ministry of Justice oversees. The judicial authorities in Scotland and Northern Ireland have a number of 130 between them, in addition to this cohort. The MOJ has assessed 732 of that 949, and these data are available publicly on gov.uk. And I can give you more information if you would find that useful.
That's fine, thank you. Section 5 of that Act includes cautions. Now, there has been some confusion in the inquiry as to which compensation scheme is going to compensate people who receive cautions. In your view, which is the appropriate compensation scheme or redress scheme? Sorry.
So cautions could be in scope of OC if the work that was being undertaken was voluntary. So if, for an example, a partner was helping, say their partner with the records for the accounts, and then ended up being cautioned because of alleged falsification of accounts, that individual could be in scope of the OC, but most are actually picked up by the HSS scheme and the GLO scheme, where there are cases of people with cautions in scope.
And those whose cautions are overturned by this new legislation, where would you say they should be applying to?
Well, I would expect anyone in that situation to be in scope of the HCRS, this new scheme, but I think I should probably check that with my team. The OC cohort tends to be a bit more bound because it generally is people whose cases were overturned by the courts, as opposed to this legislation. But I can share further information with you if you would find that useful.
Thank you. There's a category that isn't covered by the new legislation. That's those who were convicted and appealed unsuccessfully to the Court of Appeal because they didn't satisfy the Horizon System essential prosecution criteria. What is the plan for those individuals?
There were a couple of different categories actually that were excluded when Parliament reviewed the legislation. There were DWP cases as well, which is something that the Advisory Board has been discussing actively. Court of Appeal, as you say, and also other offences like capture-related offences, which are, all of which are outside the scope of the legislation. The Advisory Board has been discussing the DWP cases and liaising with DWP about them. There's no active plan relating to Court of Appeal cases that I am aware of, although, as I say, this is more a matter for MOJ to reach a view on. This was quite contentious when the legislation went through Parliament, and there was quite a strong voice from the judiciary that those cases that had been determined by the highest court, effectively in the Court of Appeal, should not be overturned, whereas those judgments reached by a lower court could be. And that was a decision made by the executive and Parliament.
Two very brief topics before I hand over to others. The first is bankruptcy issues. You've addressed those in detail in your first witness statement from paragraph 114. Do you see any current issues insofar as that is concerned, and specifically with reference to any differences between how those matters are treated between the Horizon Shortfall Scheme and GLO participants?
So I think that the inquiry's intervention was very helpful in getting us to get a direction in relation to Moors, which helped us tackle that particular issue for the GLO group of claimants who were affected. So I think that has moved things on significantly. I think there are clear principles in place in relation to bankruptcy, although some cases I know from Dr. Hudger were a bit contentious at the point of discussion with the panel, but I think there are principles now in place for how to deal with bankruptcy claims, but I'm probably not close enough to the detail for that. We did have a concern which has been expressed publicly, I know, by one victim who is within the scope of the HCRS scheme, because early in the running of the HCRS scheme, there was a question about the approach that the official receiver would take in relation to bankruptcies and the claim on the estate. But that has actually now been resolved, and we are now able to make payments to those individuals who were falling foul of that uncertainty with the official receiver.
Thank you. Final topic is current priorities and current matters at the Post Office. I don't need to take you to, there are some documents in your pack that relate to concerns at the Post Office about the increasing number of losses at the Post Office and how to address that matter. I don't know if you've seen the various correspondence with Fujitsu in this inquiry regarding future prosecutions. What do you see as the plan going forward to address issues with discrepancies going forward?
So in my mind, those are slightly distinct issues, although I recognise there's an interrelationship between them. I think under Nigel Rowton's leadership, the company's taking quite an active approach to trying to bring postmasters with them on the discrepancies and losses issue. So they, I know, have been taking steps to bring the NFSP and I think the Voice of the Postmaster into the Chesterfield office to come and see the back office that deals with discrepancies, and various steps were taken, such as the dispute button, which I think was used a bit less than the Post Office had expected, and there were various training interventions and so on that were pursued. And Kevin Hollinrake mentioned earlier the conversations that we had with the company about that. What I believe is going to happen is that the Post Office is going to bring in someone external to have a look at the current Horizon system. When I saw the YouGov survey that the inquiry published, I spoke to Lorna Gratton ahead of a Post Office board meeting and said, this is even worse than I thought from what I'd heard from the company. She raised at the board meeting, I understand, the need to get some independent assurance for us and for the company. And I understand that Nigel was of that view himself anyway. And so there are plans in place to bring in someone to provide a bit more confidence to everyone involved about how the system's operating at the moment. I think the issue with Fujitsu is probably something you should discuss with Paul Patterson. There was a bit of a dispute between him and Nick Reed around this issue, I know, I think earlier in the summer, where I suspect that the Post Office feels when the police approaches it requesting data, that it needs to release the data to the police, but they need some checks and balances around that. But I'm not closely enough involved to be able to tell you what the Post Office is doing.
Thank you very much. So there are just some questions from Mr. Henry and Mr. Jacobs and from Mr. Maloney as well.
Before they do, can I just be clear about the questions I asked you about the greater emphasis on speed of delivery, right? And your answer is clear, but what I didn't follow up with you and should have is whether that steer, that I'll call it a gloss on the earlier steer, is a steer which was given to you by the previous government, or by this government, or by both?
Yeah, the answer is by both.
By both, right. That's fine. I just wanted to know. Fine. Right. Who's going first?
I'll go first, if I may, sir.
Can you swap places with Miss Page, and so I can see you, Mr. Henry?
Sorry, sir, I was...
No, not...
cover.
Oh, even late in the day, I like to see the questioner.
Thank you. You've made... Hello, Mr. Creswell. You've made two statements, reasonably long length. You haven't mentioned Mr. Cooper in either of them, but you did mention him when you were being asked questions by Mr. Blake earlier today. And the impression given was that Kelly Tolhurst, the minister, was not particularly happy with Mr. Cooper's performance, or would it be right to say judgment calls? Is that fair?
At that early point in my tenure, that is the case. She became more comfortable with him over a period of time, but what I was describing was a particularly sticky patch early in my tenure, in the sort of April-May period, which was the fallout from the judgment.
Yeah, the fallout from the judgment. How well did you know Mr. Cooper?
I worked as closely with him as I now work with Lorna Gratton. The reason I spoke more about, the reason I didn't really mention Tom Cooper was my statements are of a moment in time,
Yes.
principally about now, where I work with Lorna and have done for about 18 months, I think.
So you've worked closely with him. I mean, he was he not, displaying a very pro-post office line, wasn't he?
I don't think that is the conclusion that one would reach, having heard evidence from members of the post office who have spent quite a lot of time in this chair complaining about an overly interventionist approach taken by Mr. Cooper.
Well, that might have been philosophically the fact that he was supposed to be a non-executive director who thought that actually that maybe he wanted to have an executive role, but he was aggressively taking the side of Poll in the litigation and also on the recusal issue, wasn't he?
Well, I wasn't around at the point of the recusal. I believe he recused himself from the discussion about the recusal. I found him not someone who wanted to be an executive in the company, but someone who felt that the company wasn't conducting itself as well as it should throughout the organisation. And he did put quite a lot of pressure on the executives in the company, and they didn't like that. But that was what we wanted him to do.
Can I just ask you, do you know Josh Scott?
I do.
You do? Because in November 2019, Mr. Cooper commissioned Mr. Scott to do research on sub-postmasters and their background stories and that which they had mentioned to the press about the tragedies that had befallen them.
Okay, I don't recall that, but
No.
I understand what you're saying.
Later on, and I can, no need to take you to the document, but so that the reference is clear for the inquiry in due course, it's POL 00337435. There is a note of a consultation with Mr. Altman, Queen's Counsel, at which Mr. Vamos, whom you will have known from Peters and Peters, was present, where the following is stated: board desperate to decide whether to take pot shots at Misra, and then further down in the document, and it is at page 3 out of 4 of the document, there is a reference to Tom Cooper and Tim Parker. Need to say, quotation, Misra has been saying X in the press. What our actual review of her case is X. Presumably it meant Y. And then Mr. Altman says that he knew Misra well. And does that not... I mean, if you'd been aware of that, you would have exercised caution, would you not?
I
mean, that's dirty pool, isn't it?
Well, that certainly sounds like a strange approach to be taking. I think in defence of Mr. Scott, I imagine he was doing what he had been asked to do in terms of factual material.
No criticism of him at all.
Okay.
No. But that surely, that would set alarm bells, would it not?
It certainly should do, and I don't recall seeing that at the time. The strategy of attacking postmasters is not a winning one.
No. Thank you very much.
Who's next?
Hello, Mr. Creswell. I represent a large number of sub-postmasters who were affected by the scandal. I want to ask you about delays in the GLO scheme. You said at the beginning of your evidence that you've taken much more control in relation to redress, and that's come across as your evidence progressed. Many of our clients were members of the GLO, and they have expressed to us concerns that their claims are taking inordinately long to finalise. And I think from what you've said, there are over 80 claims outstanding. Is that right?
In terms of claims that have not yet had offers?
Yeah. All those that have had offers that haven't been accepted.
It must be something like that. I don't immediately have the numbers to hand, but it is something a bit like that, probably.
I'll quote you, and correct me if I'm wrong. You said 306 claims received, 221 claims paid.
Well, 295 offers have been made.
Okay.
To the 306.
Okay.
So there's obviously a gap between the 295 offers and the 228 that have accepted, but there is always a lag because we may have issued an offer at the end of October and the claimant hasn't yet replied and would do so soon. I think the most relevant fact, which may support your argument, is there were about 39 or 40 claims that were formally challenged.
But about 80 outstanding, is that right?
Do you mean of the 295 offers that have been made?
Those that haven't accepted and are still involved in the scheme?
Yeah, I make it 74, but...
Very well.
Yeah.
Well, we're nearly there, aren't we? So the delays, you will know that the GLO was announced in June 2022. The scheme was published in March to April 2023. And then there was a 38-week period where the Post Office provided disclosure, at the end of which. So the scheme wasn't really in operation until January 2024. Is that right?
That sounds slightly later than I have in mind, actually, about when the GLO started running, because in January 24, that was when we launched the 75,000k fixed sum. And you'll remember from the earlier correspondence that we were discussing, this was during Kevin Hollinrake's evidence, we were discussing the scrutiny threshold it must have been about the September of 2022. So the scheme must have been, at that point, do you remember I was saying in my correspondence that we were handling cases every week? So it must be earlier than the time that you are saying to me.
Well, the point I make is that it only really got going after the disclosure exercise had been concluded, because that was the point at which it was possible to instruct accountants to deal with the disclosure and assess the losses.
I mean, there were steps along the way, such as the 19.5 interim payments, 19.5 million interim payments that we got out early on. But in terms of the part of the process in which you are most interested, that had to be later on, and disclosure did take
a while. Yes, and I'm talking about the ability to instruct a forensic accountant.
Understood.
And you're aware, no doubt, that the scheme is beset with delays at the moment, because the current problem, I think it's been alluded to, is that there are only a limited pool of forensic accountants, and so there's a bit of a bottleneck because they're all dealing with a number of claims. And the inquiry has had very sad news on a number of occasions, including today, that core participants have died before receiving full compensation. Do you agree that it's imperative that the department does everything possible to address continuing delays in this scheme?
I do agree with that. I do. And it's very regrettable that people have died without full compensation. I completely agree with you.
Paragraph 81 of your statement, you say that the department has made further interim payments to GLO postmasters suffering hardship.
We have.
And you cite the risk of bankruptcy or the loss of a home as examples where payments have been made. And at paragraph 151, you say that interim payments for medical expenses are automatically approved upon receipt of a medical report that supports the need for treatment. Would such payments cover medical expenses where a sub-postmaster, for example, needed medical treatment within a short time frame, but wanted to do so privately because they didn't want to wait and be in a queue?
As far as I'm aware, they could well do. We discussed this with the advisory board last week around cognitive behavioural therapy, where some claimants are still in the system and have not had full redress and need money to access that sort of support. And my team confirmed in that conversation that that was the sort of thing that we could provide funding for. I've personally signed off hardship payments for people who are struggling with their gas bills.
Well, exactly. And what if a close family member was struggling or needed medical care, a spouse or a child, for example?
I think I would need to check the exact approach, but I think, obviously, as I mentioned earlier, the principles around whether family members are included or not is something where there is a line. I think the impact of an individual seeing the harm that has fallen on a family member as a result of the Horizon scandal can be funded through compensation schemes. That's a sort of indirect funding. Yeah. I don't know if a family member comes along and says, I need funding to pay for this bill, whether that particular bill would be covered through the payment to the postmaster, or whether what we would do would be to provide a hardship payment against a head of loss from that main postmaster, and then it was up to the postmaster or former postmaster to decide how to spend that money, if you see what I mean.
We have clients who are here today, and I won't name them, but I'm told that people here today have received such payments in respect of family members with medical conditions, and others have had pre-existing medical conditions that have deteriorated, and they've received payments in relation to that. But don't you think that the availability of payments for sub-postmasters, former sub-postmasters or assistants or family members who are struggling for whatever reason is something that should be published? It's not something that people should have to go to their lawyers and write letters to make requests for. That should be information that's freely available.
That's quite an interesting point, actually. I mean, my team and I try hard to ensure that postmasters who need money whilst they are still in the system can access that money. And obviously we've had waves of interim payments, but we have also approved quite a large number of hardship payments, and the definition of hardship is very loose. It's quite a low bar. So maybe that is something that I should take away and discuss with my team. There is a trade-off between how much time is spent by claimants, victims, lawyers, and departmental lawyers in handling small requests for funding, and then getting to the end of the challenge cases and getting payments out. Of course, small amounts of incremental requests every week would probably be excessive, but the principle of trying to ensure that people aren't suffering whilst they're waiting for their claim to be completed seems inarguable. So maybe we should amend our guidance to reflect that.
That's helpful. And it's also noted that you say that the definition of hardship is, the words that you used are loose and low bar. So it's a wide discretion, isn't it?
Correct.
Thank you. My next question then is in relation to at 5 to 4, I think, today, in answers to questions from Mr. Blake. You spoke about the publicly available figures in relation to overturned convictions and people who qualify under the Act. Can I just ask you to confirm that that information is the quashed convictions management information published by the Ministry of Justice?
That's correct, from the 1st of November, and it was included latterly in the bundles.
Yes, I think what was included was October's number, so I'm not going to take you into that. But there was one for the 4th of November that's been published in the last, obviously, couple of days. And you said in your evidence that there's a cohort of 949 in England and Wales.
Yes.
And 732 have been assessed.
Yes.
And there's a cohort of 130 in Scotland and Northern Ireland.
Yes, 100 Scotland, 30 Northern Ireland.
And have they been assessed?
I believe that they are in the process of being assessed, and letters have started to issue. There was a press notice from the Scottish judicial authorities as well, which you might want to look at to see how far they've got.
And the figures that are published I think, say that 441 individuals in England and Wales have been sent a letter.
Correct.
And do you know how many have replied? Because this isn't recent, this is over the whole period, isn't it, that letters have been sent?
How many have applied is linked to how many people have submitted claims, and that's 172 people. That's up from 104 the previous month. So every day we are getting large numbers of people who have received those letters applying. Can I just take the opportunity to give a couple of other bits of information around these stats that I think are relevant, which is that the MOJ, the Ministry of Justice, is now getting to the point where they don't have evidence for everyone. So they've written out to lots of people, which are quite straightforward. You might have heard this through the discussions that my team holds with you on a regular basis. There are 116 people in addition to the 441 who have been assessed and either have already been written to or will be written to, saying, we think you might be in scope, can you provide more evidence? So back to that point I made earlier to Mr. Blake, there are two ways in. We have a bit of a Venn diagram, people that have come in of their own accord and people from the evidence base. A point that I think hasn't been expressed publicly really very clearly is that 949 for England and Wales includes the 111 overturned convictions cohort. So the list that the Post Office provided included those whose convictions have been already overturned.
I think it's 104 letters have been sent out to
That's correct.
people to clarify whether they are...
You're looking at the same table as me.
Yes, we are. We've heard, the inquiry has heard, finally from me, the inquiry has had evidence from the Post Office that searches are ongoing in relation to sub-postmasters who were in post during the relevant period to see whether there may be further people whose convictions have been quashed. What attempts is the department making to obtain responses from people who don't respond and to look for people who haven't been identified yet but may be in scope?
So this is a question really that the Ministry of Justice is dealing with. I understand they've employed external search. Are you okay?
No, yes. Please continue.
I understand that the department, the Ministry of Justice, has recruited some external search experts who are searching for people. I have also passed on to them the offer that I think you may have raised previously about the NFSP saying that they could perhaps help, and I've passed that on to the Ministry of Justice. They are also following up where there are no responses to the letters that have been sent.
Okay, I have one further question to ask you. I understand that of people that you've written to, how many of them have registered?
I don't have that statistic here, I'm afraid.
And are you able to answer this question? What is being done to find those who have not registered?
Well, that was what I answered earlier.
Okay. Well, that's very helpful. I don't have any more questions for you.
So there are no questions for Mr. Maloney.
So I think that's it then. Thank you very much, Mr. Creswell, for both your witness statements and for your oral evidence this afternoon. We will resume at 10 o'clock tomorrow morning.
All right, thank you, sir.